Morning, Judge.
Morning, Mr. Lee. How are you doing?
Good.
Awesome. Thank you, Miss Anna, for getting us up and going and for getting our live stream. Excuse me. Are we going to have any procedural matters that we need to deal with before we continue the evidentiary portion of our hearing today? Let's see. Let's get a few more people in. Well, while we're waiting another minute or so, anyone have anything procedural we need to deal with? I don't have any takers so far.
Your Honor.
Hi, Mr. Du Bois.
Good morning, Your Honor.
How are you?
I am okay. How are you?
Well, I'm kind of sad about Simone Biles withdrawing from the gymnastics team competition. But then on a positive note, I had a beautiful rainbow off the deck this morning that I wish had been coupled with rain at my house. It seems to rain north and south and east and west of my house, but now I know what it meant when I looked at surrounding records and found out that I live in Poverty Flats. And I think that must be because it doesn't rain.
Lack of rain.
Are you are you going to have a? Well, I see that we have everyone, I believe, except for staff. I don't see the commissioner.
I just
There he is. Go ahead, sir.
I can give an update on both the witnesses Your Honor had indicated you had questions for and where we'd suggest slotting them in, and I can update on status on bench responses as well.
Okay, I'll wait one more minute. See if we have any more participants today. Excuse me.
Madam Hearing Examiner, this is Joan Drake. I just wanted to touch base with you to see if you were okay with the format in which we filed or uploaded our exhibits that Mike Gorman is going to be adopting, or did you want us to do anything else with those at this point?
And I'll address that. That's on my list, Ms. Drake. Thank you.
Thank you.
Okay, I believe I don't see anybody else in the waiting room. So, Mr. Lee, are we ready to go?
Yes, Judge.
Appreciate it. Good morning. We are resuming our evidentiary hearing in case number 20-00238, and this is in the matter of Southwestern Public Service Company's request for a revision of its rates, among other things. As parties know, not only are we Zooming this hearing, but we also are streaming on YouTube. And so with that, I asked if we had some procedural matters, and I believe Mr. Du Bois, you have some updates for us.
Yes, Your Honor. Thank you. Will Du Bois for SPS. First off, on witnesses, Your Honor had indicated that you had questions for Mr. Lytle and Mr. Cooley. And what we would propose would be, I think we're slated to pick back up today with Mr. Shipman. And then we had Ms. Martin and Mr. Moeller following them in our proposed order of witnesses. We would suggest going from then Mr. Moeller to Mr. Lytle, then Mr. Cooley, and then picking back up with Mr. Berger.
Okay, so Mr. Lytle, Mr. Cooley, Mr. Berger, all after Ms. Martin.
I'm not sure I heard that right. So after Ms. Martin, Moeller, Lytle, Cooley, Berger.
Okay. So after Mr. Moeller, Lytle, Cooley, Berger.
Yes, Your Honor.
Okay. Thank you.
And Your Honor, I can also provide an update on bench response
Okay,
status.
go ahead.
Number 3 should be getting uploaded, filed, and circulated momentarily if it hasn't already. Number 4 should be.
No, wait,
just a few-
I thought, hold on, Mr. Du Bois. I thought bench request 3 was who can answer questions about the IRP.
We had also, we had discussed providing as a bench response the data for that as well.
Okay.
So 3 is what I have as providing that data, and it would actually be Mr. Goodenough who would be the witness to discuss that with.
Okay, when is he available?
Let me get back to you very quickly on
Okay.
that. I'm sorry.
Okay, let me know when the data is going to be circulated and provided, especially provided to the chairman and myself, everyone to be provided at the same time. But and then also when Mr. Goodenough is available, because I'll just go ahead and caution the parties at this point that any of the witnesses, well, not really caution you, but advise you that any of the witnesses that the commission has questions for are not going to be able to be questioned during an approximate 5-hour period tomorrow when the commission has other pressing business in its open meeting. So we'll be calling other witnesses from 9 to 2 tomorrow, and hopefully the commission will have concluded its meeting, and then we can resume with any witnesses that the commission has questions for. So With that in mind, anything further, Mr. Dubois, on bench request 4, 5, or 6?
4 should be going in shortly. Should be following number 3 pretty closely behind. And we are still on 5 figuring out the public versus confidential piece and hope to have that promptly. Hoping by lunch today. I hesitate to commit on that, but we're trying to work through it, Your Honor.
Okay, and 6? Same?
Oh, yes, Your Honor.
Okay. Anything further from SPS? Mr. Dubois?
No, and I will give an update on Mr. Goodenough shortly.
Okay, very
He will
well.
be available sometime today. I'm just trying to figure out how late in the day.
Okay. And we just need to, like I say, make sure that we have, because I don't think that the chairman's going to want to hear from him if he doesn't have the information to the bench request. So,
Certainly, and like I said, that will be going in shortly.
okay. All right, we just need to make sure we have time to read it. Okay. Do you want to say anything else on that, Mr. Chairman?
Yeah, just one comment. All I was looking for was the growth rate. Excuse me, I'm just getting myself together here. Yeah, I wanted the growth numbers from the IRP, and in terms of any additional data, I'm only interested in data that backs up how we got to that IRP number. I'm not looking for new forecasts. So I just want to be sure that that's what we're getting.
And Chairman Fishman, will do voice for SPS. To be clear, I think, SPS had a 2018 IRP and recently filed its 2021 IRP. And I believe we'll be providing you both numbers.
Okay, terrific. Thank you.
And I would just note that I believe Commissioner Hall will be having questions on the 2021 IRP that relate to compliance with the 19-00170 STIP claims regarding talk, and whether or not there has been compliance with those representations, especially those that were set to be complied with the 2021 IRP filing and before. And so Mr. Du Bois, you can think about, since it's a different question set on the IRP, whether or not Mr. Goodenough can answer those questions, or do we need to go back to Mr. Grant, who testified on compliance items?
Without, Your Honor, knowing quite what the questions are, I have a suspicion that would mean Mr. Grant, because Mr. Goodenough would have the piece on, I think, load forecasts, but what it's sounding to me like with respect to TOLP would probably be different from that.
And and I don't have the 19-00170 STIP in front of me, Mr. Du Bois, but my understanding is the commissioner has interest in, again, representations that were made about replacement, the process, and the assertion assertions that were made about the processes that were going to be utilized regarding the closure of Tolk and going forward. Okay.
Okay, thank you.
So yeah, so we just need, to get that, to get that step out and see what everybody agreed to, and make sure that it's done, because the commissioner, I believe, would like to ask you about it.
Thank you, Your Honor.
Okay. Mr. Chairman, you clarified that. Anything further regarding bench request 3?
No.
Nope. Okay. Well, before we leave SPS, and Mr. Lee, other than
Ms. Hurst, this is Mr. Marks.
hello, Mr. Marks.
Ms. Hurst, I don't think I really have a right to have a say on this, but if my preference has any relevance, if there's going to be a witness who's asked about the compliance with the Tolk analysis and the 19-00170, I see that the company has Miss Benny Weeks set as a witness, and I think my client would prefer that she respond to those questions, because we think she's the most knowledgeable.
And I appreciate your opinion on that, Mr. Marks. But ultimately, I think that Mr. Du Bois can, once we get that step out, I think he can determine which is the appropriate witness. But thank you.
And
Understood.
Depending on what the questions are, I don't miss.
I'm sorry,
sorry.
can you start again? There was an interruption.
I'm sorry, Will Du Bois for SPS. Depending on what the questions are, Mr. Marks very well may be right. Partly trying to hedge my bets on guessing who might be able to better answer the questions depending on what they are. So we'll just have to figure it out.
Okay, and I, Mr. Lee, I'm just trying to figure out, other than the exhibits, the three commission exhibits, 1, 2, and 3, and the testimonial exhibits, are you showing that we have any other exhibits admitted at this point?
No, ma'am, but we do need to admit the exhibits Ms. Drake was talking about.
Right, and before we do that, I guess, well, I believe that you offered, Mr. Du Bois, you offered SPS exhibit 51 yesterday.
Will Du Bois for SPS, Your Honor. We only actually used what had been pre-marked as 53 and moved that. And I think it was admitted as 53, notwithstanding that means we didn't actually have a 51 or 52 in order there.
Okay, so you are not offering 51 or 52.
Correct, Your Honor.
There it is. There it is. Okay. All right. Mr. Lee, did I send you 53?
Yes, ma'am.
Okay. All right. SBS also emailed. Okay, that's what SPS emailed. Okay, so that takes care of that. Now we have Miss Drake. You have mentioned that you emailed the revised versions of FEA LES 5, 6, and 7. Is that correct?
That's correct, ma'am. We, for each of those, we noted on the cover page of each that they were being adopted by Michael P. Gorman, and we included Mr. Gorman's qualification statement and his affidavit for each of them.
And that was necessitated because of the medical issue with Miss Alderson and her inability to testify here today. I did instruct that we needed to make sure it was clear in the record that Mr. Gorman was going to adopt his testimony and that there be a verification with each of those documents. I would assume that the parties have had an opportunity to review FEA LES exhibits 5, 6, and 7. Are there any objections to FEA LES exhibits, revised exhibits, and I say revised from what was initially filed, and I'm not hearing any objection. So the FEA LES exhibits 5, 6, and 7 that have been revised to include the verification and a new cover page are going to be the FEA LES exhibit admitted into the record. Okay, anything further on that, Ms. Drake?
No, ma'am, thank you.
Okay. And I guess, okay, Mr. Lee, I just sent those to you.
Thank you, ma'am.
And like I say, just would note, these are the admitted ones, not the ones that are FEA LES exhibits 5, 6, and 7 in the Dropbox. And speaking of the Dropbox, nice segue, Elizabeth. I, pursuant to a Herculean effort by Anna Kippenbrock, our hearing examiner assistant extraordinaire, as I had indicated to the parties over the weekend, the chairman had requested that the responses to his bench requests become commission exhibits, and for your review, we have already admitted commission exhibits 1, 2, and 3 without objection, and I was able to download commission exhibits 4 through 28 into the Dropbox this morning for you all to see. And I'm not going to go through all of them right now, but you all take the opportunity to review those sometime in the near future and see if you're going to have any response on those exhibits. Okay, I believe that's all the procedural matters that I had that I wanted to deal with.
Your Honor.
Anything further
Your
from
Honor,
anyone else?
Michael
Mr.
McMillan.
McMillan?
For OPL.
Yes, sir.
Earlier, you mentioned that during the open meeting, we would switch over to certain witnesses that the commissioners did not have questions for. Do you have a list of those witnesses so we know what to expect?
Well, we're gonna continue on. Today, I will have a better idea. I'll have a better idea, Mr. McMillan, this afternoon. Because it's going to depend on where we are.
Okay.
Okay.
I can raise the issue again at the end of the day.
If I need to switch from SPS witnesses to the other party's witnesses, like I say, I should have a better idea this afternoon when I know where we are with the SPS witnesses. Because as we know, SPS, I believe, had 27 witnesses, and there's going to be quite a few of the SPS witnesses for which there are no questions. Okay, so chances are we may be going into some of the other parties' witnesses tomorrow morning. Okay, let you know as soon as I can.
Thank you, Your Honor.
All right. If there is nothing further procedurally, I believe, Mr. Shipman, that subject to getting some more information from you, that the chairman had completed his questions for you. Is that correct, Mr. Chairman?
That is correct.
Okay. And so I indicated to you, Mr. Du Bois, that you could have the opportunity to go ahead and ask Mr. Shipman questions based upon what's already been asked. If you'd like to do that now, sir.
Will Du Bois for SBS. Yes, Your Honor. Thank you.
Very well. Go ahead.
Thank you. And good morning, Mr. Shipman.
Good morning.
If we could, I'd like to go back. Do you recall some discussion yesterday on whether and why or why not commission acceptance of a stipulation, or, for instance, the stipulation in SPS's last rate case would make a difference to the credit rating agencies, to very generally paraphrase?
Yes.
Let me ask, would it make a difference to the credit rating agency what the contents of the stipulation was, and not just the fact of it?
Very much so. The fact that a resolution of a case came about as part of a settlement, as I indicated, would be viewed positively by a rating agency, at the outset based on the idea that it shows the ability in a jurisdiction for the parties to get together and come to a resolution that's mutually beneficial, but that does not act as a substitute for actually analyzing the case and its impact on credit quality. And so while there's something of a presumption that it's a good resolution to the case, it does not immediately lead to that conclusion. In the end, they'll analyze the case and view it through the lens of whether it's good or bad for credit quality.
So if, for instance, a revenue requirement associated with a stipulation, let's say it was enough to avoid a meaningful further degradation in the credit metrics of the utility, but not enough to improve them, would that be something that would be likely to lead to continuance of current ratings, upgrade, downgrade? How would that be received?
It sounds like your scenario is like a status quo, doesn't really change things financially or otherwise, doesn't set any new precedent or in terms of how it was arrived. That sounds like very much like something that would just result in a continuation of ratings.
I'm sorry, would result in?
The continuation of the current rating.
Thank you.
Changing topics, Mr. Shipman, do you recall some discussion, I think, with the chairman yesterday on retention of dividends and potential impacts of that?
Yes.
And if we take the hypothetical of a utility, instead of paying dividends from, well, let's maybe take an extreme hypothetical to simplify things to start with. Let's say a utility entirely stops paying dividends and uses any and all available cash flow along those lines to pay down debt and increase the proportion of equity, therefore, or actually, I'm sorry, let me start over because I want to not try to, stepping back, I can see some folks chuckling, trying not to cross-examine here and just ask questions as basically as I can. So I'm going to start that one over. Again, taking the hypothetical of the extreme of turning off dividends entirely and using those to pay down debt, what impact would that have on the capital structure ratios of the utility?
The retaining all of the profits, assuming that there are any under your scenario if things are going badly, but not paying out any of the earnings in the form of cash to shareholders would build up the equity account. So it would increase the equity component of the capital structure, and paying down debt would have the opposite effect. It would further the strengthening of the balance sheet through a lower debt ratio.
Okay, so again, to simplify,
Madam Hearing Examiner, could you just ask Mr. Shipman, please speak a little louder? I just didn't quite hear all the ending of that statement.
Mr. Shipman, could you speak up a little?
I will. And the ending
Thank
of
you.
that statement was that paying down debt lowers the debt ratio and strengthens the balance sheet, the capital structure.
and then
Thank you.
thank you. To be clear, then when that utility, hypothetical utility next came in for a rate case, its equity ratio in the cap structure would therefore be higher than whatever it was in the last case, assuming, again, as you pointed out, assuming that there had been any profits in the interim.
That is correct. Yes, it would have unless they took actions in the meantime, that strengthened balance sheet would be the one that would stay in place until they took some other actions to counteract that.
Thank you. Going back, I think to some questions from hearing examiner Hurst. Do you recall some discussion on, I think, some factors that are, we could say, within maybe the control of the utility, or more within the control of the utility in terms of operational, managerial issues, et cetera, rather than as opposed to rate case outcomes?
Yes, I recall that.
And I think one example that was given was First Energy's issues, I don't know how to put this delicately, but with some civil and I think even criminal allegations in Ohio related to some of their lobbying efforts. Is that a fair description?
Yes.
And I think another one was Pacific Gas and Electric and their operational issues and wildfire issues. Is that a fair characterization?
Yes.
And those,
that's a little more intertwined with some legal issues about their liabilities in connection with their operational difficulties.
fair enough. And just make sure I'm clear. So, those were you indicating, or is it your opinion now that both of those are kinds of things that would be viewed by the credit rating agencies and could negatively impact the credit quality regardless of action by the regulator on those issues?
Yes.
Okay. Are you aware of any negative operational issues or service quality issues that would be viewed as negatively impacting SPS's credit ratings?
No, to the contrary, my understanding, reading the testimony in the case, is that it's the opposite, really, that the SPS can show a very positive record of operational excellence.
And just to finish out and be clear, are you aware of any civil or criminal issues akin to First Energy that would relate to SPS that could negatively impact its credit quality?
No.
Thank you. I think that was all I had, Your Honor. Thank you.
Very well. Any, Mr. Chairman, any follow-up on that? You got to.
I'm unmuted. Yeah, I've got just a couple of follow-ups. I'm not, with the PG&E case, I know there was lots of controversy about them withholding information from the commission. When I've looked at the read press reports about that. Can you speak to that at all, Mr. Shipman?
I am not aware of what you're referring to. I was the primary analyst on PG&E up until the time I left S&P, and so I'm pretty familiar and followed them.
How long ago was that? I'm sorry, I kind of cut you off there.
No, that's fine. 3 years ago and prior to that.
Okay. And in the First Energy instance, what were the circumstances there, just real quickly?
Yeah, I hope I didn't confuse anything. I just brought it up because H.E. Hurst had brought up penalties and things like that, and it occurred to me that that's, you know, one of those kinds of things. But yeah, we're dancing around it a little, I think. But First Energy was accused and I think eventually convicted of improper lobbying with regard to state legislation to subsidize their nuclear plants, I guess.
Yeah, okay, that's what I was thinking.
Yeah,
that
and
was
so,
about.
and those are, you know, those are drastic examples, both First Energy and PG&E. Most utilities never encounter any problems of that magnitude, but obviously, you know, they often, or not often do it, sometimes do. And I was just using that as an example
Okay.
for H.E. Hurst, that we, you know, the rating agencies do consider a myriad of factors.
Yeah.
Besides what the regulators are doing and what the outcome of any particular proceeding is.
Right. And I would agree with you that, you know, I certainly haven't seen any of that kind of behavior from SPS. Thank God. In terms of dividends, I believe you correctly point out that the capital structure changes if you if you pay fewer dividends and you put the money into the business or pay down debt, your capital structure is going to change. Is that a permanent change, or is that something that you can, you know, as you right the ship, you can adjust your dividend and regain your prior capital structure?
Companies manage their balance sheet every day and they can adjust it. It's always struck me over the years how the equity accumulates if you're not paying out any dividend. And so it takes some effort to rebalance everything out, but you know, it can be done.
Okay. It strikes me that, and I think this is the last question, it strikes me that as we approach the rate case, we do a lot of discussion about how ROE affects the dividend, and you know, we've just discussed some other things that can be done. But yesterday you were very reluctant to say that you would adjust the dividend because of some of the impacts you talked about that it might have on investors, and you know, long term, if you didn't readjust, that it might lead to a more expensive capital structure long term. It creates for me kind of a funny symmetry, which is that we come and we use that capital structure to say we can raise rates to consumers, but it seems like, and my job is to balance interests of consumers and investors. But it seems like in the testimony we get back, we raise such a barrier to the idea that we could potentially, in some circumstance, lower a dividend, which I think is at about 65% of profits the last few years from what I saw on the record. But that we're quite comfortable raising rates. And it doesn't feel like a very symmetrical equation in terms of balancing the interests. If we're never willing to, when the company screws up, like first, what was the name of that? The nuclear fraud thing. It's not much balance if there's never a penalty when things go bad because of bad management. I mean, if the investor's getting a 9 or 10% return and there's never a penalty or a potential action that would reduce that, I'm not doing a very good job of balancing. What's your response to that?
I think I would challenge your notion that the company cutting its dividend is a penalty, and if it's done at it's caused in a sense by a regulatory decision that's somehow benefiting ratepayers. So paying the dividend does not really involve the ratepayers whatsoever. It's, that's retained earnings. Those are profits. It belongs to the shareholders. Whether the company, the board of directors decides to return some of that capital to the shareholders in the form of cash dividend, is something that doesn't really have any impact on ratepayers, and raising that or lowering that is not something that's helping or harming ratepayers. So I guess my response to you would be, if you stick to your knitting, do your job in terms of balancing those interests.
I'm sorry, sir. If you stick to your, did you say knitting?
Knitting, yeah. You do your job balancing interests, taking actions that you think are good for the ratepayers and all the other parties in the long term, and over the long term is going to deliver the services that ratepayers want at a reasonable cost. The company and their dividends and everything else will take care of themselves, and it's not something that unless the company is in a stressful financial situation, should never really enter into your thinking, in my opinion.
So, Mr. Shipman, your contention would then be that if we were to lower rates, if we were to come back and say there's a rate reduction, and if in fact we just did that in a recent case, how does that play into this configuration you're talking about?
Whether rates are raised or lowered is not really the issue. If rates go down because costs have decreased, something has rolled off that no longer hits the income statement, and it doesn't affect their ability to earn the return on equity that they are authorized to. Whether rates go up or down is really not the issue. It's whether the revenues are sufficient for a company to cover its costs, including its cost of capital, and earn a compensatory return, and that folds into all of the credit metrics and things like that on the financial side, would be what a rating analyst looks at, not at whether it was a rate increase or a rate decrease.
Let me throw out a proposition to you. You're helping clarify my thinking, so thank you for your answers. As a regulator, if we give a fair rate of return that can attract capital, should we even be thinking or worrying about credit rating, and leave it basically up to the company to manage, to be sure that it's got its credit rating? It's getting a fair return. It's competitive with the market. It can attract capital. Why would we even need to be thinking about credit rating?
I think the important difference between creditors, fixed income investors, and what the rating agencies care about, and the general financial condition of the company that you were talking about, is that there's much more of an influence on cash flow in credit analysis. It's not just about whether you're earning a return. All of that matters when you're evaluating when the rating agency is evaluating the impact on credit quality of a regulatory decision. But the cash flow matters as well. And so they look for the return of capital, depreciation rates, and things like that can matter just as much, because you can earn a return, but if it's not a cash heavy, or if it's a return of earnings and not cash flow, that's just as harmful to credit quality as low earnings that have a lot of cash flow, I guess is how I would put it. And so credit is still matters in the end. Credit quality still matters, or I believe should matter to a regulator, and should be paid attention to in addition to all the other interests that you balance.
So what I'm hearing is that the threat, and I, by the way, kind of felt the same as our hearing examiner, H.E. Hurst, that it was kind of it felt like sky is falling testimony on credit rating. So if the credit rating might get weak, we can raise the rates above a fair return. Now let's say credit rating was really, really strong. Could we then lower the rate of return?
As I went through with the hearing examiner Hurst, I wouldn't characterize certainly what I said, none of the other testimony that I saw as being kind of a false alarm or inflammatory or anything like that. I firmly believe that good credit ratings is good for all parties, and not only including ratepayers, but especially ratepayers. And so I would say that focusing on credit quality is still a useful thing for you and the rest of the commissioners to keep in mind when you're making your decisions, and your decisions on things like return and things like that is more about looking at the record, seeing what the ranges are, and coming up with what you think is a fair return.
Okay, so please respond to this. In terms of determining rates, when we look at credit rating, it's asymmetric. It can be used as an argument to raise rates, but it can't be used or to raise the ROE higher than a required market return, but it can't be used to, if it's strong, to lower the ROE below a return. It's kind of asymmetric. Would that be a correct statement?
No, I don't believe so. The credit rating criteria is indifferent to the plus and the minus of all the factors that go into it. And it's not naturally biased towards one or the other than as I related in my testimony for the kind of credit ratings that most utilities, the categories that they're in, there is somewhat of a bias more towards that business risk profile, that qualitative side of the analysis, as opposed to the quantitative side. And so in your example, a lower ROE because you think you can for lack of a better way of saying it, get away with it without causing a downgrade or something like that, may do that anyway, because that signaling effect that I talk about in my testimony in terms of where ROE is set matters very much to the rating agencies. It tells them something about a regulatory jurisdiction and its regard for credit quality.
Okay, so you said indifferent. I kind of still take that as, why are we as a commission even worrying about something that if we give you a fair return, you should manage as a company, not you personally, but SPS. But I'll just leave it at that. Thank you.
You're welcome.
Madam Chair, Madam Hearing Examiner.
Yes, ma'am, Commissioner Hall,
Oh, I just wondered if I could ask a quick follow-up question
please, go
of this
ahead.
witness. So, Mr. Shipman, I think I heard you say something about a signaling effect that would occur with manipulation of the ROE, particularly downward, that would still signal to investors or analysts who advise investors about weakened credit worthiness, I guess. So did I understand that right? Is that what you were saying?
Yes, that's a characterization, yes.
So are you saying that that would be something to avoid for purposes of maintaining credit stability?
What are you referring to when you say something to avoid?
Lowering of the ROE in order to protect credit stability.
So your question is, would a rating agency look at lowering the ROE as a credit factor?
Yes.
Yes, very much so. It's again, the evaluation of a regulatory jurisdiction, the evaluation of a company's ability to manage regulatory risks encompasses a whole lot more than just what happens in a case like this and what the headline number is in terms of ROE and capital structure and all. But as I relate in my testimony, it is a big factor and is paid attention to by rating agencies as a way to gauge whether a jurisdiction is signaling to the investment community whether they are interested in attracting capital in order to for economic development reasons, for jobs, all the things that go with injecting capital into a state. They look at ROE as a very important factor in sending a message to the investment community about the regard that they have for those kinds of factors.
And so I guess corollarily, increasing the ROE, all other factors being equal, signals the variety of positive concepts that you just referred to.
Yes.
Okay, so well, I don't know. To me that seems like a bit of a ratchet upwards, since there's only negative consequences to flow. It sounds like, with respect to from the company's perspective.
No, I respectfully disagree. If the higher ROEs resulted in better credit ratings, being able to borrow at lower rates that help, again, control the
Maybe, I'm sorry to interrupt you, but I meant to, I should have said to lower the ROE would have the negative consequences from the company's perspective. Or at least not the positive company, not the positive.
I understood your question to mean, is there an asymmetry? Is it all negative and none of the positive? And that's why what I was responding is, other than that somewhat arcane issue about how it's weighted, qualitative versus quantitative, and the qualitative is a little bit more influential at these kinds of ratings. There's a symmetry. The rating agencies have, through the years, their favorite analogy is that they're the umpire. They're not in the game. They're just calling balls and strikes, and they are indifferent as to whether it's a ball or a strike, or who's winning or who's losing that game, and things like that. And so they'll look at the ROE. They will compare it to other ROEs around the country to try to gauge regulatory supportiveness and things like that. But if it's higher, and that implies a lower risk and a better rating direction, as readily as they will go in a negative direction if the circumstances were flipped.
Okay, thank you.
Commissioner Hall, I'm just following up with a couple more you reminded me with your questions. I noticed in Ms. Martin's testimony, I think it was something like 100. She said for if there was a credit downgrade, one notch, that it would cost the company $750,000 a year in additional interest for each $100 million of debt, of new debt that they took on. Do you know how much it costs ratepayers for each 10 basis points that the ROE is increased?
I don't believe it costs them anything.
An increase in the ROE doesn't that we as regulators set doesn't cost ratepayers anything?
No, I think what you're focusing on is the near term. There's the arithmetic of, rate of return, ROE times the equity component and the debt cost and all that sort of thing. And whether that has an impact on the revenue requirement is, incontrovertible. I'm talking about looking beyond that, looking over the long term, whether better credit ratings will, and consistency in that, will actually lower costs to ratepayers. I firmly believe that not only where the ratings are now, but actually higher ratings would actually benefit all ratepayers over time. And it's I know it's not a simple concept, but
I understand you.
Okay.
And I don't have time to look at the whole record, so if I ask repetitive questions and stuff you've testified, please forgive me. Did you submit any kind of analysis that shows those long-term benefits?
My testimony goes through why I think a rating in the mid-A category is beneficial to ratepayers.
Did you do a long-term financial analysis that shows what specifically the benefits are over some period of time?
No.
Okay, that's all I need to know.
Okay.
Shipman, you're not the only witness who testifies regarding credit rating and the impacts of credit rating.
No, I believe it comes up in Ms. Martin's testimony as well as Mr. DeSantis's.
And what is the business hierarchy between the three of you? Are you in the same group?
I'm an independent consultant, as is Mr. DeSantis. Ms. Martin is the assistant treasurer. She's in the treasury group at
Okay,
Excel Energy.
okay. So I have another commissioner who would like to join the hearing. So I'm going to admit him. Good morning, Commissioner Maestas. Welcome to our hearing in case number 20-00238 UT. And Chairman Fishman and Commissioner Hall are also present at our hearing today. So, Commissioner, you just need to let me know whether or not you have any questions for our witnesses. And also, I just wanted to advise you that we are also live on YouTube for people to view the hearing as well. Okay. I believe that there are no more questions at this point, Mr. Shipman, for you. And we will await the receipt of bench request information to determine whether or not you need to be recalled to ask questions about that testimony. Is that clear, Mr. Du Bois?
Yes, Your Honor, and 4 should be going in any moment if it hasn't already. And actually, I was just going to ask then if I could step out for just a minute or two and see where we are on that and double check on our witness availability discussion from earlier.
Okay. Let me just indicate for the record that I did receive an email that I, just in case they were not included, I emailed SPS's response to bench request 3 to the chairman and to Commissioner Hall. And so for them to look at 3, and I believe if you need some update at this particular point, Mr. Du Bois, perhaps now then, so that we can be efficient, why don't we go ahead and take our 10-minute recess a little early, and we'll come back at right around 10:17. And then hopefully that's enough time for you to get the information that you need. Okay, so we are recessed until 10:17. Okay. I believe we are about at the end of our there he is.
I apologize, Judge.
Not a problem. You're the most important person in the hearing, Mr. Lee, and you are here. I believe our 10-minute recess is concluded, but I'm only seeing the Excel symbol, I guess. Or is that the SPS symbol?
That's a yin and yang, I'm pretty sure.
Is that what that is?
I don't know.
Well, we'll have to ask Mr. Dubois what that symbol is. What's this? That's an Excel symbol, or is that a yin and a yang, Mr. Dubois?
That is the Excel Energy logo, and I cannot speak to what the inspiration for that particular design was.
Okay. Very, very well. Will you have an opportunity to update us as to where we are in bench request land?
Yes, Your Honor. 4 should be filed and circulated at this point. Yes, I see the email has gone out at least with containing the response to 4. And right now, I understand Mr. Goodenough could be. I'm sorry.
Go ahead, sir. No, I was just exclaiming that, oh, I have it. So go ahead.
I understand Mr. Goodenough could be available by 3 p.m. today. I'm trying to see if we can get him available earlier than that, and we'll update you if it's earlier. But right now it would be 3 p.m. And we are continuing to work on number 5 and this, trying to answer in a complete way on public information is something we're still struggling with. And, we recognize at some point we will just need to look at going to confidential information if necessary, but we're still holding out hope we can provide a good answer on that will work. And we're still working on 6, and that should be soon.
Okay, so basically then as far as the lineup, you'll have Mr. Goodenough available for bench request 3. And once we've had a chance to look at bench request 4, we'll recall Mr. Shipman. Correct?
Right.
Okay, but during the pendency of that, you're ready to go ahead and call Ms. Martin. Is that correct?
Yes, Your Honor.
Okay. Mr. Chairman, if you're available, since bench request 3 and was your bench request, are you going to be available at or about 3 o'clock?
Yes, I can be.
Okay, very well. Thank you, sir. And Very well. So while we're looking at those things, I guess, as we can, Mr. Du Bois, you have another witness, sir.
Yes, Your Honor. We have Patricia Martin up next. And she is here with
And
me.
thank you, sir. Mr. Lee, could you swear in the witness, please?
Ms. Martin, would you raise your right hand, please? You do solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
And it's my understanding, Mr. Du Bois, that Ms. Martin had direct, rebuttal, and stipulation testimony, SPS exhibits 15, 16, and 17, which have already been admitted into the record, correct?
Yes, Your Honor.
Very well. Good morning, Ms. Martin.
Good morning.
I have a few questions for you, and I believe that Chairman Fishman also has some questions for you. And I believe you've already gotten an introduction from Mr. Shipman in that you are the assistant treasurer for Excel.
That's correct.
And the part of your testimony that I have a few questions about, of course, have you been listening to the proceeding?
I have.
So you know that the commission is concerned, as apparently SPS is concerned, about SPS's claim of how the commission action can affect SPS's credit rating as viewed by the rating agencies. Correct?
Yes, correct.
And sort of my characterization as it seems as if there is a significant effect being claimed by SPS on an action by the commission that does not comport with what SPS or the parties want in this case.
I'm sorry, was that a question?
Did you, well, did you, have you heard my concern that that's what it appears that the SPS testimony is in this case?
Yes, I agree that that is a concern, and that you and others on the commission have iterated that you're concerned about that. I do think that a lot of my testimony is about potential rating agency reactions to certain decisions that are made by the commission. And the reason we're so concerned about that is a couple things. One of them is it directly impacts the cost of debt that gets passed through to the ratepayers. It can also impact our access to capital markets in certain volatile conditions. And then thirdly, I've heard you use the word doomsday, and I don't want to make it seem like this is entirely a doomsday scenario. But I do believe the commission needs to know that there are practical implications and consequences based on our own experience with the Moody's downgrade from 2018.
And I don't believe I referred to a doomsday scenario. I think perhaps that was a chairman. My comment, potentially ill-advised, but it seemed appropriate at the time, that it's more like the sky is falling. The sky is falling from 2 or 3 of SPS's witness, about potential effects on from commission action and how they are viewed, I guess, by these rating agencies. So, did you listen to Mr. Shipman's testimony?
I did.
And yesterday, I asked him a series of questions about commission action and how, in his opinion, they were viewed by these credit rating agencies. Did you hear that testimony?
I did.
Do you disagree with my observation or agree with my observation that it appears that there's only one situation where the rating agencies may or may not have considered the commission action, that being in case number 17255, as having a potential effect in their ratings.
I disagree with that. I believe the case that you're referring to is you were talking about the CCN filing that was made in that case. I do agree with that part of your commentary.
Well, wait, no. Hang on just a second, Ms. Martin. I believe 17255 was the rate case, and hasn't SPS alleged that the commission action in that case led to the ratings downgrade?
SPS is not alleging that, just to be clear. We're quoting a report from Moody's that they wrote based on the outcome of that rate case. And yes, the decision in that case was part of the reason for the downgrade. If I may, that case was about the Tax Cut and Jobs Act. So SPS was asking for a higher equity ratio to make up for the cash flow deficiency that would be caused by the higher tax rate. We asked for a 58% equity ratio. The commission gave an initial decision of a 51% equity ratio. And I believe that the ROE recommendation was 9.1%, which was significantly lower than the ask. Moody's made a decision in that case to downgrade SPS based on the cash flow implications to credit metrics, as well as their view of the non-supportiveness of that decision to SPS's financial integrity.
Okay. So you're claiming then that it's Moody's who negatively interpreted the commission decision, not SPS.
That's correct. And I believe I have their report attached to my direct testimony as one of my exhibits. And I was directly paraphrasing their comments in that report.
Okay. But my questions to Mr. Shipman yesterday then expanded on, and I think you started to testify about this, expanded on to this one decision And would you agree that SPS has had quite a few cases since 17-255 before the commission?
That's correct.
Okay. And including 2 cases that I was referring to yesterday, one being the 17-00044 CCN cases, where the commission approved the building of Hale and Sagamore wind farms. You're familiar with that case?
I am not, but I listened to the testimony yesterday.
Okay. And you don't doubt that the commission approved those because they've been built, right?
I don't dispute that.
Okay. And as a matter of fact, that's one of the big reasons we're here right now, is to try to get the Sagamore wind farm into rate base, correct?
Correct.
Right. And then the last rate case, 19-00170, that was a SPS rate case, correct?
Correct.
And the big impetus of that case was to get the Hale wind farm into rate base, wasn't it?
Correct.
Okay. But, if you heard the questions yesterday, it sure doesn't seem like that, based upon this information and my observation of the information, it's like, if we don't go along with SPS, it seems like that the assertion is, oh, we're going to get downgraded. But yet, when we do go along with SPS, you don't get upgraded. So that's why it kind of puts me in a conundrum about how important we need to, to look at this assertion.
Yes, I can understand where your thought process is there. If I may, there was also a 2016 rate case, and I'm sorry, I'm not good with case numbers, so I don't have that in front of me, that was thrown out. And then we had the rate case that we were just speaking of, where the Tax Cut and Jobs Act, TCJA is the acronym, if I happen to slip and say that again. So I think there was 2 kind of negative decisions that caused the downgrade, although Moody's does not talk about that dismissed rate case in the particular report I was referring to. And unfortunately, the rating agencies are very slow to move back up after they've downgraded a company. They take kind of a wait and see approach in terms of not only gauging the regulatory supportiveness, it's more about kind of seeing a pattern of consistency and predictability in decisions, but it's also about looking at cash flow, and is your cash flow and your credit metrics position strengthening? And then in the case of SPS, even this settlement stipulation, while we're very supportive of it, will not do anything to improve our credit metrics. It will just help maintain our rating and our credit metrics where they are. So I think that's why you're not seeing the rating agencies move the other way, because even in some of our supportive decisions that were made, as you quoted, and Moody's did actually publish a report in January of 2020 in relation to the last settlement that called it credit supportive. So I think they are recognizing that those things are happening. We just haven't seen the corresponding very strong increase in cash flow metrics that they're also looking for, in addition to the pattern of consistent, predictable, supportive rate making.
Well, in that's sort of a segue, thank you, for my next question, and just generally, because I think that Chairman Fishman was asking some of the prior SPS witnesses, but I'm going to go ahead and ask this just so that I understand. But I know, beginning on page 29 of your direct testimony, the question posed at line 7, what is an economic capital structure and how does it impact credit metrics? You are referring to Mr. Shipman's testimony, and you say, as Mr. Shipman discusses, the credit rating agencies make certain adjustments for off-balance sheet items and impute these adjustments as additional debt. Then moving on to page 30 to continue the answer, calculating credit metrics. Examples of these adjustments are for purchase power commitments, leases, underfunded pension obligations, and asset retirement obligations. A company's economic capital structure includes the consideration of these items. That's your testimony, Ms. Martin?
That's correct.
So how many of those examples of, are there any other adjustments in addition to the adjustments that you included in your testimony?
There may be very minor adjustments, but those are the material adjustments that the rating agencies make.
Okay. And then in the next sentence, you say, beginning at line 5, SPS has a number of off-balance sheet obligations that the rating agencies include in their analysis of credit metrics. During 2019, S&P identified $358.5 million of debt adjustments for off-balance sheet items for SPS, of which approximately 75% were for purchase power agreements and operating leases. After those off-balance sheet obligations are taken into account, the actual economic equity ratio considered by the rating agencies is far lower than the regulated equity ratio. That's your testimony?
That's correct.
Okay. You go on to say, for example, a regulated equity ratio of 54.72% translates to an economic equity ratio of 51.27% under S&P's methodology. The regulated equity ratio thus understates the true leverage considered by the credit rating agencies because it excludes off-balance sheet items as well as short-term debt. Correct?
Correct.
So maybe then the actions taken by SPS regarding these adjustment items have more sway with the credit rating agencies than the commission decision of perhaps not always agreeing with what SPS wants. Couldn't that be?
I respectfully disagree with you. I believe, although I'm not involved in the IRP hearings very much, that if the company enters into purchase power agreements, I believe that's a decision that is ultimately approved by the commission. So the level of PPAs, as an example, is not a decision that SPS is making solely on its own. That's a joint decision. And the company does have to enter into leases for certain things like buildings or equipment or things like that to manage costs efficiently.
Well, so you don't think if when SPS is negotiating or entering into a lease contract or a PPA contract, or in dealing with its pension obligations or asset retirement obligations, that if its pencil was a little sharper and it cut down on its debt or what it agreed to pay, you don't think that would have an effect ultimately on what the credit rating agencies, how they evaluated SPS's actions.
I do think the company does a very good job of trying to keep all of our costs competitive. But one thing that I would like to point out is that in a lot of cases where we're negotiating contracts, our credit rating does come into play in terms of the cost or the security that's demanded by our counterparties because of the relative riskiness of SPS as indicated by our credit rating.
Well, it seems like I did a financing for you all, at least in the past year, and that you had a really competitive debt issuance. Was it like 3.15 or something like that?
It was, that's correct.
So how, I mean, I thought that was a good rate. I mean, how, you're the assistant treasurer, you tell me. Were you happy with that 3.15?
I think for SPS, we were happy with that 3.15. A couple things. So bond issuances are priced based off the underlying treasury rate, meaning if we're issuing a 30-year bond, it's based on the 30-year treasury, plus a spread. And the spread is dictated by your credit rating or your risk evaluation is another way to say that. And then sometimes there's an additional spread if there's market volatility at the time you happen to be issuing. So I do think that in relative terms, a 3.15% coupon that we issued in March of this year was competitive, but I'd also like to point out that we reopened a bond that we issued in 2020 for the 2021 issuance to just add, you kind of can add more money onto it in certain economic conditions. So the coupon was already dictated. That's part of the reason that we chose to reopen a bond, to make sure that we kept costs very competitive this year. The spread that SPS is paying above the treasury rate has increased since our downgrade in 2018. So we are paying a higher spread at SPS than any of its higher rated sister companies. So although we did manage to get good financing for the SPS rating, it's not as competitive as what we're seeing for some of our other regulated utilities.
So you're saying that the other the other Excel regulated utilities are more highly rated by these credit agencies than SPS is.
Correct.
Therefore, they're getting the better rates than SPS.
That's correct.
And then looking at your stipulation testimony on page 8, section 5, financial integrity. The question begins on line 2. What is your assessment of SPS's financial integrity? And you start out your answer on line 3. SPS is currently rated a B, small a 2 by Moody's, which is below average for credit quality as discussed in my rebuttal testimony. So that's the downgrade that you're referring to?
That's correct.
And explain to me what does it mean below average?
Sure. So on
average of who?
the average of all regulated utility operating companies. So if I'm remembering my numbers right, Moody's rates around 113 regulated utility operating companies. SPS is one of, I want to say it's 14 companies that are rated Baa2. There are only 4 companies that are rated still investment grade, but less than SPS. So that would mean Baa3, or in S&P vernacular, it's triple B minus, they call it. So all of the other utility operating companies are, other than the ones I just mentioned, are either Baa1 or above. So it just means that the rating that's been assigned by Moody's is higher, indicating higher financial integrity and less risk.
So if SPS were to be downgraded, then you're saying they would be in the bottom 4. Now they'd be the
Yes.
bottom 5. Okay.
Correct.
Okay. And you've said that while SPS is supportive of the stipulation, that basically the monetary implications of the stipulation, you do not believe are going to improve SPS's bottom line, right?
In terms of cash flow credit metrics, which is really what the rating agencies base the financial part of their analysis on, it does not improve our metrics. It does allow them to continue to remain stable. And then the other part of the analysis that rating agencies perform, of course, is the business risk analysis. I think that approval of the stipulation agreement would be another positive step for the rating agencies to see regulatory support and consistency that could indicate to them that they may want to be looking at a potential upgrade in the future. But I think we would also need to see a little more improvement in our cash flow credit metrics in order for that to happen. But it definitely puts us on a consistent path.
So then basically from what I'm understanding you're saying is that even if the commission agrees with the stipulation, you don't anticipate the credit agencies are going to give you an upgrade at this time.
I don't believe so, no.
What's got to happen from the SPS actions to make that occur?
I think at this point, continuing a pattern of very positive, supportive rating agency decisions, as well as the continued, I'll say there needs to be some improvement in our cash flow credit metrics. 2 factors there. Obviously, as I just mentioned, cash flow is one of them. And then the bottom half of most of the denominator is affected by debt. So I think that the company needs to, as we are, in my opinion, doing a good job of managing our expenses, really making sure we're looking at any O&M expense, trying to keep our cost of debt low, which we can do if we maintain our current credit rating. And just continuing those kinds of actions will show from our side a pattern of strong financial management.
But if you look at your cap structure, I mean, you're into the 50s on your equity component. So, I mean, isn't your cap structure in the higher end of the utilities as far as your equity debt ratio?
Yes, I would say that our equity ratio is high, but if I can please refer you to my rebuttal testimony on page 26. I'm going to go back to the economic capital structure for one moment, if I can.
Okay.
This is an update to the testimony that you were reading in my direct. So we did update the economic capital structure as of the end of 2020. These are the actual adjustments that the rating agencies make. So even though our 54.72 equity ratio that we're asking for does appear to be very strong in and of itself, what the rating agencies see in making their determination is they're going to impute not only the 352 million of off-balance sheet debt that we were talking about, but when they're looking at our debt to equity structure, they're also including short-term debt. So in their mind, our 54.72% equity ratio is really 49.49. That's what they're
I'm sorry. In their mind, our 54.72.
Sorry, I was speaking too quickly. Equity ratio is really 49.49. So when we're making an ask of the commission in terms of what we think our regulatory equity ratio needs to be, we are taking into account these adjustments that the rating agencies will make to determine our credit metrics.
Okay.
Madam Hearing Examiner.
Yes, Commissioner Hall.
Could I just ask the witness for clarification of that last statement again? How is it the debt equity ratio appears different to credit credit analysts under the circumstances described?
Okay, and hold on just 1 second. And I will. There we go. Parties, commissioners, you should be able on the screen share to see the table, I believe that Ms. Martin was referring to on page 26 of her rebuttal testimony. So Ms. Martin, if you could just go through now that we have that up and clarify for the commissioner.
Sure, thank you so much for doing that. So the regulated equity ratio as of December 31st, 2020, excuse me, was actually 54.74. It was a little higher than what we're asking for. The rating agencies, though, when they're looking at our capital structure and calculating our credit metrics, they also impute additional debt onto our balance sheet for things like purchase power agreements, capital leases, pension obligations, and asset retirement obligations. So just using PPAs as an example, I know Mr. Shipman talked about this a little bit. So purchase power agreements are contracts that we are obligated to make payments out into the future. Rating agencies actually view that as a very debt-like obligation. So what they do is they'll take the present value of that stream of payments that we're obligated to make, and then they discount PPAs based on a risk factor. I believe Chair Fishman was talking about this yesterday. They do give some credit for the amount of certainty in recovering those PPA costs since they are a pass-through. So PPAs, for example, are imputed at a discounted rate. Any leases that we have that are not already on our balance sheet, get imputed
I'm
at the
sorry,
net
ma'am.
present value.
I'm sorry, ma'am. Can you start that statement again?
Sure, just about the leases.
After you said are imputed at a discounted rate.
Okay. I think I was talking about leases, if I remember correctly. Any leases that we have that are not already on our balance sheet get imputed at 100% of the net present value of the payments we're obligated to make. Pension obligations, the rating agencies will look at what our report, and this all comes from our 10K statement, if I forgot to say that. Pension obligations, they look at what our pension liability is versus what we have in our pension fund. And then they'll impute the gap as debt. That's a much lesser amount than PPAs. And then asset retirement obligations, they look at if we have some environmental things that we're obligated to do, or if we're in the process of decommissioning a plant or something like that, they'll look at funds that we already have aside for those activities versus what our obligation is. And then they will also add debt to their calculation. And that's how we're getting to the 352 million shown on the off-balance sheet debt line in this chart. And then the last thing is rating agencies will also include short-term debt in their calculation. Even though we do not have short-term debt in our regulated capital structure, they do consider it debt that we have to pay back at some point. So that's how you go from a regulated equity ratio of 54.74%. The rating agency view of that will be 49.49%.
Commissioner Hall, anything further on that?
Yes, well, I have this witness here. What's the cash flow of the company currently, or whatever time frame you can tell me? Reasonably current.
I do not know that number off the top of my head. I'm sorry.
Can you get it to me?
Yes.
Mr. Du Bois, consider that as bench request 7.
And
Yes, sir.
and also, what are the company total revenues? You just,
I'm sorry, I don't know that off the top of my head either.
yeah, if you could just add that into the request and make them the same time period.
Is that currently, Commissioner, or your revenues as set forth in your stipulation or your testimony?
Well, I would say relative to the stipulation.
Sorry, Will Du Bois for SPS. I want to make sure we're answering the right question on the total revenues piece then. Am I understanding right then that what you're looking for is what the revenue requirement indicated by the stipulation is, and not a actual revenue number for some historical period?
No, I'm at the company's total revenues for this year.
Right.
Or for this
Yeah.
recent quarter. Whatever your most recent metric is.
Okay.
Which may not be the same thing as the revenues that were presented for illustrative purposes for the stipulation exhibit. Is that correct?
I think if
you
I'm
asking
following
me?
right, they can't be the same.
I'm sorry, Mr. DuBois, can you start again?
I said, I think if I'm following correctly, those two cannot be the same, and we need to get some historical actual revenue data for Commissioner Hall.
Okay,
Well, Madam Hearing Examiner, you're raising an important point, and this needs to be the revenue figure that would pertain to the stipulation timeframe.
well, and again, Commissioner, in their agreement, part of what they've agreed to is to provide the commission with, with a base rate increase and numbers, and then there's an adjustment, and there's a lot of different components, but what was actually agreed to may not be the revenue requested by SPS for the historic base period in this case. So if you look at Exhibit A, page 1 of 7 to the stipulation, it will show you that that there a number for total present base revenues, total present revenues, and then we'll show you the base rate increase, and then the other factors in there. So we have some.
Okay, so if it's in our data, pardon me for interrupting, if it's in some, that document you just identified, I can see it there. But I'd still like to know the cash flow figure, unless we also have that. I wouldn't expect it.
I can't put my hand on that or in the witness's testimony. So consider that bench request 7. Any further questions, Commissioner Hall, of Ms. Martin?
No, thank you.
Okay.
Madam Hearing Examiner.
Very well. Ms. Martin, have you had an opportunity to look at the answer to bench request 4?
I have.
And bench request 4 Mr. Shipman had offered criteria that explains how credit rating agencies rate particular actions by commissions, and then he has a response on that. Have you reviewed that?
I looked at it briefly this morning.
Based on your knowledge and experience of credit ratings, and as the assistant treasurer for Excel, do you agree that the information does in fact assist in trying to help the commission understand what the credit rating agencies are looking for?
I do agree.
And do you know whether or not there is some other information source that you think would be helpful to provide to the commission that could additionally assist the commission in understanding what the credit agencies rely upon when they make their decisions?
No, what we use when we're performing internal analysis is the document that Mr. Shipman shared, and just in terms of the adjustments that the rating agencies make, S&P publishes the most transparent report on the adjustments they actually make to credit metrics.
And you did in fact include as an attachment to your direct testimony, attachment 3 from S&P, correct? And it
My attachment 3 is just a recent rating agency report on Southwestern Public Service, specifically from S&P.
What about,
It's not the ratings methodology document that I was just referring to.
and what about 4? Exhibit 4. That's also
Attachment. I'm
Yes.
sorry, I didn't mean to interrupt you.
no attachment PLM4 is another S&P ratings document.
That's correct, specific to SPS.
Okay, so now how do these differ from the other S&P document that you're talking about?
Oh, I'm sorry, I probably confused you. So I believe Mr. Shipman actually did an attachment that talks about how the PPA adjustments are made by S&P. S&P also publishes a document that's just their methodology for all adjustments that they may make to credit metrics.
Okay, where is that?
I don't think I attached it to my testimony.
Is there a claim that it's confidential?
Nope, we've included it in testimony prior to this case. We can definitely share that with you.
Okay, let's consider that bench request 8. Ms. Martin, I thank you. And those are the questions that I had for you. Mr. Chairman, do you have questions for Ms. Martin?
Yes, I do. Thank you. I'm going to go back to page 30 and talk a little bit about, or try to explore a little bit about these adjustments. We just went through a rate case.
Commissioner, page 30 of which of her documents?
I'm sorry, page 30 of the direct testimony.
Go ahead, sir.
And we just went through a rate case with another utility that has PPAs. And I'm sure they have leases too that are off book. I don't know that for a fact, but at any rate, when we considered their capital structure, there was no discussion of any of those adjustments by the rating agencies. And there was, frankly, none of that was taken into consideration in coming up with the proposed capital structure. So my question to you is, why would we want to take them into consideration here?
We're not directly asking you to do that, what we're trying to do is, when we're asking you for a 54.72% equity ratio, what I'm trying to say is we have already taken this into consideration in terms of what the rating agencies are going to impute onto our capital structure. So the reason that we need to think about it, and that we're asking you to think about it though, is this is what our credit metrics will be based on, is the imputed, including the imputed debt by the rating agencies. So as an example, if I may, if the commission were to authorize a 50% equity ratio in this case, what the rating agencies will actually see is something much less than that. So that is definitely going to make a difference when they're considering what they calculate and what they look at in determining our credit ratings.
So as H.E. Hurst pointed out, your on-book equity ratio is much higher than other utilities. And recently it was, somewhere around the 50% range in our most recent case. And it's kind of what we typically see. But you're at 54.72%. And your explanation for it is that you have to have a higher ratio because of these off-book debts. But what I'm saying to you is we just went through a rate case where the company that had PPAs did not do any gross up of that, nor did they ask for it. So it feels like you're making an adjustment that other utilities don't make, and it's resulting in a much higher actual cost capital structure. Is there any reason that you're doing that and other utilities we regulate are not?
I can't speak to what other utilities are doing. They may be doing the calculation behind the scenes and just not being as transparent about factors that they're taking into account. I can tell you that S&P.
Just be clear, what I just told you was they basically took their book numbers and that's what we worked off of. So there were no behind the scene calculations. It was not even discussed. Was not even part of the discussion, no part of the consideration. So we're looking here and suddenly we see all of these off-book things that are used as an explanation for why yours is higher. But that explanation to me doesn't wash because the other utilities that we deal with have a 50% ratio and they didn't see any need to make an adjustment upwards of their actual capital for these off-book liabilities that you talk about. So what's different about SPS that they need to make these adjustments but nobody else does?
First of all, I think I dispute the fact that no one else does, because S&P imputes debt in a similar manner to every utility. So we are not claiming that we are the only utility that S&P will make this adjustment for. This is their standard practice.
Again, you're misstating what I asked or what I was pointing out. What I was pointing out is they didn't see the need to adjust or to raise their actual equity ratio because of what the credit rating and the credit agency said. They just went with their book.
Okay.
So why is SPS different?
First of all, SPS is actually asking for a 54.72% equity ratio, which has been authorized in the last two cases, I believe. And we have been managing to that equity ratio. So what we're asking for is indeed our actual equity ratio. I think the whole conversation about economic equity ratio is an informational point for the commission to be aware of, that when the rating agencies do our calculations, they are actually imputing additional debt over our equity ratio.
Okay. I'm just going to reiterate the fact that other utilities have not seen fit to have this high, expensive for ratepayer equity ratio based on the fact that a credit rating agency happened to call something an off-book liability. That Excel is, at least in what I've seen so far, unique in making that argument. I'm going to go on to the next point. I'm very concerned about the idea of PPAs being considered an off-book liability. And if you were listening yesterday, you probably heard my questions about that. We have utilities that are doing most of their renewables development, and there's going to be a lot of it, with PPAs. And I'm having a hard time figuring out why a PPA is considered an off-book liability. And the reason why is that it's a flow-through cost. Is the cost that's paid on the PPA is recovered very quickly, within a month or two, through our fuel and purchase power clause and through the renewable rider. If I'm paying $1,000 this month for a guaranteed pass-through compensation a month later, where's the risk? Why does that impact anything? How is that considered a liability? Or if it is considered a liability, why am I not taking the cash flow, or why am I not taking the flow-through payment and booking that as an asset?
Two responses to that. I think the reason that the rating agencies look at PPAs still as debt is because the obligations go out so far in time that even though there is very near-term certainty of recovery, since they go out so far, anything could change in that amount of time. Mr. Shipman talked about yesterday, the rating agencies do take into account, though, the recovery and the lower risk because of the recovery mechanisms that are in place. They don't take the entire net present value of the PPA payments that will be due. They discount that by some factor that varies between 0 and 50%. So the amount of PPAs that are showing up as an adjustment, according to S&P, is much lower than what we report in our 10K in terms of our total PPA payment obligations.
Mm-hmm. Leases, if I understand correctly, according to, I guess, Financial Accounting Standards Board, they're going to start, apparently from what I understood from Mr. Shipman's testimony, they're going to start going on book, those liabilities in the future. Is that correct?
That's correct.
Okay. I get that. A lease, you make a payment. You have no guaranteed recovery. You just make a payment and it becomes a liability. Again, very different than what happens with the PPA. So let's take what else goes into our fuel clause that we get flow through on. We get, when we buy, when a utility buys fuel, that again is passed on directly as a flow through through the FPPCAC. That is not listed as an off-book liability by the credit rating agencies. Is that correct?
I don't believe so, no.
Okay. So from a regulator standpoint, I guess my sense is the credit agencies can do whatever the heck they want, but I don't quite understand why we should be allowing you to take a higher equity ratio because of the PPA.
The higher equity ratio, and first of all, I a little bit dispute that it's by saying higher, yes, relative to 50%, but at our PSCO subsidiary, we have a 55.61% authorized ratio, and there's a lot of factors that go into that. One of the reasons that we also are maintaining and asking for a higher equity ratio at SPS is because the nature of the historic test year in Texas and New Mexico, which leads to regulatory lag. So in order to generate the cash flow that we need to maintain our credit metrics and our rating, we have to maintain a higher equity ratio to, this is not the word I want, but to make up or overcome the regulatory lag. That's just a natural part of a historic test year case.
Once again, I don't see why what you're facing is anything different than what we're facing with our other regulated utilities who have a much lower equity ratio. I understand what you're saying, but I don't understand why that's different than anybody else we regulate.
Well, I'm sorry, but I don't really know the specifics that went into all of those other cases. I can only speak to the equity ratio that we are proposing, and that is part of the settlement, and the other parties are also deeming reasonable and fair, is what SPS needs to maintain its financial integrity.
Okay. So what I'm going to just, I think we've covered that territory pretty well. I'm going to add, I'm going to take a little different tack here. What do you believe that regulators should, as a practice, adopt the actual capital structure that exists as the capital structure to use in a rate case?
In general, yes. I think that as long as the equity ratio is reasonable, as long as the company can show that they've been managing effectively to that ratio and it's not completely out of bounds with other utilities of similar risk, I do think it's good practice to adopt the actual equity ratio.
If a utility were to just before a rate case decide to do either a huge debt pay down or a big equity issuance that changed that capital structure just before a rate case, how would you deal with that situation? How would you look at it?
That's a good question. I think that that's part of the reason that I think somewhere in our discovery, and I'm sorry, I'd have to look, but we make it a practice of providing capital structures over time so that you can see a pattern of consistency in terms of what we're managing to. In your example, I think a utility could choose to manage their capital structure differently right before a rate case, but then I think the commission could have every opportunity to ask the utility why in fact they did that, and for a pattern of history in terms of what they've been managing to.
Mm-hmm. So a thought that's going through my head here is that, again, I'm having a real hard time getting past how a PPA can be considered a liability, and the fact that as you're testifying here, you're basically saying you've grossed up your equity structure to account for these off-book liabilities that the credit agency has identified. And my instinct is, if it's not a cash flow risk, we shouldn't be allowing you to gross up your capital ratio to account for it. Quite honestly, based on the evidence, that's how I feel. I just want to give you a chance to give a final response to that, and then I'll let you go.
Sure. Thank you for giving me the opportunity to respond. I disagree with your statement completely. The last authorized equity ratio in I think it was our 2019 case, was 54.77. What we're asking you for is actually less than that. And we've been managing to our authorized ratio. And that is our practice to manage to that. So there is no grossing up of the equity ratio for PPAs. This is the equity ratio that will support our financial integrity.
Okay, I respectfully disagree, but I respect your point of view on that. But thank you very much for testifying. Appreciate it.
Thank you.
Madam Hearing Examiner.
Commissioner Hall, do you have questions of this witness?
I do. I want to follow up on a couple of concepts that were raised by Commissioner Fishman, and I think maybe also by you. Let's see. And so if I could proceed?
Please.
Okay. Let's see. Ms. Martin, that's the right name, right?
Correct.
Let's see, I think you mentioned in response to a question raised by Commissioner Fishman, it was a little bit more elaborate than what I was able to write down, but essentially you were saying you need a higher equity ratio to maintain adequate cash flow. And that's all I captured there. Do you recall that statement, or can you address that concept?
Sure. So the important point I was trying to make about cash flow was that our primary credit metrics, which go into the financial analysis by the rating agencies, are based on cash flow and debt. So the equity ratio is a really efficient way of maintaining your cash flow, because it not only affects, let me back up, I'm sorry. So one of the main credit metrics that the rating agencies all look at is cash flow from operations, so internally generated cash flow divided by debt. So if you're looking at an equity ratio to support cash flow, not only does it add cash flow to the numerator, but it also reduces debt in your denominator. So the equity ratio is really important to us in terms of financial integrity, because it very efficiently manages your cash flow. And it also manages the financial risk of the company, because if you have a higher equity ratio, you have less debt in your capital structure, which leads to financial risk. The reason that's so important to rating agencies is, remember, what they're trying to do with a rating is signal the amount of financial risk to investors. Investors care about getting back their interest payments for the debt that we have outstanding, as well as their principal. So we care about that, because not only does it directly impact the cost of debt that we're issuing, but it also, basically, the higher our credit rating, the more investors that it will attract, and the easier time we have getting capital. And then we have more pricing leverage to push down the cost of that capital.
Okay, so what things have you done to improve your cash flow?
I can't speak to all of the things because of my limited function, but I know that the company always has programs going on to look at our O&M spend, to make sure that we're looking at processes more efficiently, trying to save money in that context. I do think in terms of my world, when we are out issuing debt, we're trying to make sure that we're doing that in the most efficient manner possible. We're trying to put as much pricing leverage on investors as we can. And one of the ways that we can do that is to maintain our credit rating.
Okay. Well, I'm looking at your attachment PLM 4 on page 4.
Of my direct?
Of your direct testimony. And it is the Standard & Poor's Global Ratings Direct. That's the title of it, Ratings Direct, issued by Standard & Poor's Global Ratings. I think it's for the year 2018. So I don't, yeah, it's dated November 6, 2018. So it may be out of date. But I did notice, I was taking a glance at what it says about in describing your company. It says at least at that time, your business risk was excellent, your financial risk was significant. So I looked at that, and I'd like to take you to page 4. I want to ask you some questions about the financial risk.
And there.
It says, our standalone financial risk profile for SPS incorporates a base case scenario that includes adjusted FFO, which is funds from operation. So I take it that's money that you generate from your operations. That includes adjusted funds from operation to debt, averaging about 16% below the midpoint of the benchmark range of the significant category. We expect a supplemental ratio of FFO cash interest coverage to be in the 5x to 5.5x range, supporting the existing financial risk profile. In addition, operating cash flow after capital spending and dividends, or discretionary cash flow, to be mostly negative over the next several years. This indicates a need for external funding such as debt issuances and cash injection from within the Xcel Energy Group. So they say over the next few years, we expect debt leverage to be relatively aggressive. So what I wanted to ask you was, since then, since 2018, have you issued more debt or gotten more cash injections? Because this looks like this is an area where, management of those features could improve your cash flow and would alleviate some of the pressure on the need for higher equity ratio, as you say. Have you guys been doing these things?
We have. So we have issued. Oh, I'm sorry. Are you guys getting? Can you hear me okay?
There's a echo on the line.
Can you guys hear me okay?
I could hear.
Now we can.
Okay, thank you. We have issued debt in each of the last 3 years since this report was published. We also, as I mentioned, we manage to the authorized equity ratio. So every time we issue debt, we also infuse equity into SPS to make sure we're maintaining our authorized equity ratio. So we have been doing both of those things on a regular basis.
Let me interrupt for a minute. When you say every time you issue debt, you impute equity, can you explain that?
We infuse equity from the parent company.
Okay, great. Okay, go ahead.
The other thing I wanted to comment is I think part of the cash flow concern was our elevated capital expenditure program because of Hale and Sagamore. So we did have to issue debt to fund the shortfall between FFO and our capital expenditure needs.
Could you explain that a little more?
Sure. So that just means our internal cash flow was not sufficient to fund all of our capital spending. So whenever there's a shortfall, which I think S&P had mentioned here, they expected discretionary cash flow to be negative. That's what's causing us to issue additional debt and then also infuse equity into SPS.
So have you corrected the cash flow problem, or do you still have it?
No, utilities by nature tend to be cash flow negative. So I don't expect that we'll entirely ever be able to fund all of our needs out of just internal cash flow. One of the things that's part of my job is looking at what we need to issue in debt the next year out. We do anticipate we will need to issue additional debt in 2022 as well.
So do you know whether you've gotten away from this financial risk rating of significant since 2018?
I think I have in one of my, it might be the attachment right before this, is maybe a more recent S&P report, and I believe it still carries a significant financial risk.
And then you say you will be issuing more debt. So well, never mind. I guess that's all for now, Madam Hearing Examiner. Thank you very much, Ms. Martin.
Commissioner H.E. Hurst and Commissioner Hall, I've got a couple other quick questions, if I may.
Mr. Chairman?
Thank you. So Ms. Martin, how much on an annual basis, let's just say the last fiscal year, did SPS pay out in dividends? Do you have a?
I don't know off the top of my head, but I think that was in one of our bench requests.
Was it? I can't even, sorry.
No, that's okay. There's a lot of data here for sure.
Yeah. And I thank you. Your answers have been very clear. I appreciate it.
I don't know if I'm remembering a bench request or if I'm remembering discovery. I apologize. I'll find it. It is a discovery question. It's LES 1-11.
Mm-hmm. And the answer was?
Would you like me to just give you 2020 or?
Yeah, 2020 is fine.
Okay.
Just ballparking it.
Okay, dividends were $321 million. And if I may, equity infusions into SBS were $439 million.
Right.
Sorry, I'm sorry, we're what number?
Did you want the equity infusion number or both?
The last number.
439 million.
Thank you.
in answering questions before, you said you managed to your authorized equity capital ratio. If we were to change that capital ratio, would you continue to do the same?
Yes, we would.
So what we decide as a capital ratio has a definite effect on how you manage and a definite effect, depending how you manage it, potentially on dividends paid out.
That's correct.
Okay. That's it. Thank you.
Ms. Martin, where was what was the source of the $439 million equity infusion?
Sure. It was a discovery question that we got. It was LES 1-11.
No, not the source of the information. I want to know who was the source. Where did you get the $439 million of equity?
Oh, I'm sorry. You're actually asking where it came from.
Yes,
Is that
ma'am.
correct? Yes, it comes from the parent company.
Excel.
Excel Energy, yes.
Okay. And all of that was during 2020?
That's correct.
Thank you. Mr. Dubois, do you have any redirect for Ms. Martin?
Will Dubois for SPS. Yes, Your Honor, I do. I also have a couple of legal / record issues I wanted to raise as well.
Okay. Does it have to do with her testimony?
It has to do with the examination that's been taking place. And I'll just thinking out loud, I don't anticipate why it would be a problem for Ms. Martin to be present for the discussion, but I can conceive of a scenario where it might not be the preferred option for the hearing examiner. And commissioners, I don't know which way to go on that. I mean, normally I would just jump in, but I want to be sensitive because this is ground I'm not usually on. I can.
Well,
give you,
I mean, we're on YouTube,
yep, that's true.
Mr. Dubois. This is a public hearing.
Yeah, I'm
So,
sorry. I'm not.
I mean, are you are you asking me to you know, come out of the public domain to discuss an issue, or?
Your Honor, thank you for the reminder. I'm not totally used to the brave new world where we can't just ask a witness to leave the room for a minute. I will just go forward and be careful on how I put things. Thank you.
Okay.
So there were two things I wanted to raise. One, I think, is kind of a purely legal issue. I know there's been some discussion about, I don't know how to phrase it, but the automatic, I think is what it's been called, recovery of PPA costs. And I think a legal point of clarification is we can file something on this as well, but I don't believe that's legally true in New Mexico. There is commission prudence reviews, not just before the fact, but also after the fact on these. And I know in particular, the commission just ordered very recently a review to take place next year on some current costs that SPS has. So we've had, I think it's said that it's automatic, but as a matter of law, if the regulation were to change and make it automatic, I'm not going to sit here and complain, but I think it's, as a matter of law, the case that it is not automatic. There may be an immediate revenue that kind of tentatively
Is there a
comes.
decision, Mr. Du Bois, is there a particular decision or commission rule that you'd like me to take administrative notice of about the way that costs are recovered regarding PPAs in New Mexico?
I think the recent order in docket number 21-00046 explicitly said the commission was going to be doing a prudence review of PPA costs. And if you give me a moment, I can point to the rule as well, or I can come back to that.
I mean, like I say, once you have the information you'd like me to take administrative notice of, why don't we deal with that at that time?
I'm happy to defer to your preferred approach. My general point of view is if it's a rule or a law, a statute, we don't need to take administrative notice of it because it is what it is as a matter of law. It's not a matter of evidence.
No, and I appreciate that, but I think that, like I say, if you want to make sure that we hone in on the point that that you believe is important to the case, then I'm happy to consider your request to take administrative notice of that. Okay.
Thank you, Your Honor.
Okay, and then you have another something else?
Yes, Your Honor. There was discussion of what are essentially fact issues from EPE's most recent rate case, that we are in a problematic position on where SPS can't examine, we can't do discovery on EPE, we can't cross-examine EPE or dig into that in any way. And I have reason to think that EPE actually has minimal PPA costs, and I can come at that a couple of directions to help illustrate it more. But very fundamentally, just as a matter of record evidence, we don't have anything to work with or any ability to question or challenge that. And that is definitely something that I would explore under different circumstances. That EPE's case isn't part of the record in this case, and I can't do any follow-up with EPE.
So are you making a motion, Mr. Du Bois, with regard to
I'm not sure what motion I could make to unring the bell on that.
So let me ask it differently. What course of action are you proposing then to either procedurally or legally to address an issue that, from what I'm hearing from you, you believe is either inappropriately been put into the case, or contrary to law has been put into the play into this case?
Well, and part of what I'm struggling with is kind of a two-level issue, which there's statements in the record, but even if I were to, I don't want to make a motion to strike that, but even if I were to do that, it doesn't change, that we have a challenge of kind of already having that there is a belief as to that information, whether it's in the record or not. I mean, I can do my best to try to give illustrations as to why we would suggest we don't think that is correct and try to counter it from an evidentiary standpoint. But again, I can't do anything directly with EPE about that, right? We do have Ms. Martin having, I think, expressed concerns, I'll say, with whether she assumed that it was right or not. And I can point to some things that I would think reinforce that, but I'm in and I apologize to not have a specific motion to make. I'm just trying to explain what I think the issue is, and that I'm not sure I have a motion that really takes care of the issue. So perhaps I'm noting the issue and asking for indulgence on trying to maybe take some slightly unusual steps in trying to explain why that's a concern.
Okay. Well, you're going to need to think about that, and I don't know if you can, potentially have a conference call with your other stipulating party counsel and come up with something on that or not. Basically, what I'm hearing from you, Mr. Du Bois, is that you believe there's a significant issue with regard to either factual and or legal issues that has been brought up in the context of Ms. Martin's testimony, that you feel that due process affords you some opportunity to either have a legal remedy or a evidentiary remedy, and you haven't figured out yet what it is. Is that pretty much hit the nail on the head?
I think that's a fair summary, Your Honor.
Okay, so you think it over. And obviously, if we're just talking about opinion versus evidence, that's one thing. And obviously, the ultimate decision in this case, at least the recommended decision that I will offer in the case will be based on the facts that are in evidence, as well as my legal interpretation, and not my opinion or someone else's opinion. It's going to be based on evidence. So I just put that out there, and like you say, I think you're going to have to hone in on exactly what you think has occurred that you might think is detrimental, and how you best think it should be fixed or not. Okay.
Thank you, Your Honor.
And while you're doing that, do you want to go ahead with any questions you might have of Ms. Martin, Or do you want to wait and think about how you want to proceed with regard to your second issue?
I think, I mean, I have things I could certainly proceed on and maybe just reserve on whether there's anything that I would ask to come back to on that piece.
Okay. Well, why don't we go ahead and see what else we can hear from Ms. Martin before we take our lunch break.
Thank you, Your Honor.
Okay, go ahead, sir.
Ms. Martin, wanted to come back to one thing that there was quite a bit of back and forth on, and I'm not sure I got it clearly, but just to ask the question very directly, has SPS made any adjustment to its actual capital structure in its request in this case?
No.
And would using, for regulatory purposes, a hypothetically lower equity ratio in the capital structure, if applied to the revenue requirement, directly reduce cash flow?
Yes, it would.
Thinking about some of the discussion of SPS relative to EPE, take it first kind of more abstract, not getting into PPA questions, but just at a high level. Or maybe we can assume, I think we can try making it hypothetical. Let's say we have SPS at, I'm sorry, what did you say the actual equity ratio is?
54.72%.
Thank you. We have SPS at a 54.72%. And the equivalent of a triple B standalone rating. Do I have that right? If we express it in
correct.
Okay. Sorry, just to make sure, since we're talking over a little bit, if we express it in S and P terms, it's expressed as a triple B.
Yes, that's correct.
In our parlance.
Correct.
Okay. Let's say we have a hypothetical other utility that's at a 50% equity ratio, both for actual capital structure and for regulatory purposes. And it is also at a triple B rating. Do you have those assumptions?
Hypothetical utility at a 50% equity ratio, also a triple B rating.
Great.
Correct.
Would it be fair to say that the rating agencies are looking at that comparison and taking into account the SPS 54.72% equity in determining the relative risk of the two utilities?
Yes, that would be a correct statement.
And if you had SPS, instead of having a 54.72% actual and regulatory equity ratio, but instead having a lower actual and regulatory equity ratio, that would comparatively increase the risk relative to the other utility. Do I have that right?
Can you just repeat the question part of that again, please?
Sure. And just to make sure we're on the same page on the hypothetical again, we've got SPS at a 54.72 equity ratio and triple B.
Yep.
We've got another utility at a 50% equity ratio and a triple B. And we imagine, I'm sorry, strike that and we imagine. We've established already, you already said that, with that equity ratio difference, that is what still brings SPS to having the same risk profile as the hypothetical utility.
Mhm.
If SPS had a lower actual and regulatory equity ratio than 54.72, that would then lead to SPS having a worse risk and credit profile than the hypothetical utility.
That's correct. So anything less than the 54.72 that we're managing to would degrade cash flow. It also, if we were to be authorized a lower equity ratio, we would manage to that, which would add debt to the capital structure, which by nature increases the financial risk of the company.
Okay. And when you were talking about the rating agencies' consideration of PPAs and leases in how they look at risk, is it correct that they are not accounting for PPAs at a 1-to-1 ratio of the PPA obligation versus what they're imputing in looking at risk?
That's correct. They discount the total net present value of future payments based on a risk factor that takes into account the recovery mechanisms to recover those PPA costs.
But adding more PPAs would increase not on a 1-to-1 basis, but still increase what the rating agencies are considering there.
That's correct.
And you mentioned that SPS's PPA counterparties look at and make decisions partly based on SPS's credit rating.
That's correct. So they use the credit ratings as an indicator of financial risk of the company and certainty of payment of those obligations. So a lower credit would indicate maybe more risk of getting payment of those obligations. So in turn, they may either negotiate the price of the PPAs or they would require more security from SPS in terms of backing that payment stream.
And if you know, would a rating agency looking at an SPS PTA counterparty consider SPS's credit rating in determining the risk and credit rating of the counterparty?
I'm not sure I understood the question. Could you repeat that, please?
Yeah. So some of, I don't know if all of, but some of SPS's PPA counterparties have credit ratings. Is that right?
Correct. That's correct.
And the rating agencies are looking at their risk profile in developing those, right?
That's correct.
Would, if you know, would the rating agency look at the fact that the counterparty has a PPA with SPS and take into account SPS's credit rating in thinking about what risk the counterparty has?
I don't know if I know the answer to that. I'm sorry.
Okay. If SPS were to exit PPAs that it has right now and build more power plants itself, would that more closely align the credit rating agency's views of SPS's credit metrics with the actual SPS capital structure?
Yes, because there would be less off-balance sheet obligations. And if we were building any additional generation instead of doing PPAs, we would fund that based on the authorized capital structure.
Actually, if I could have one moment, hearing examiner Hurst, I think Commissioner Fishman actually asked some of my questions, and I can get rid of those. Ms. Martin, there was some discussion of SPS's equity ratio relative to other utilities. Do you recall that?
I do.
And I think you'd mentioned Public Service of Colorado as one in particular that you knew offhand had a higher equity ratio.
Yes.
To your knowledge, are there other operating companies that Xcel Energy is not affiliated with who have also have higher equity ratios, higher actual equity ratios?
There are. I couldn't name one off the top of my head, but Mr. De Ascendas has some testimony that points out the reasonableness of our ask in terms of equity ratio based on a proxy group.
Okay. I have one other topic, and if I may, I would like to read back a question from the rough transcript from yesterday as the lead into the question, because it's something that Your Honor has asked about of Ms. Martin and also was asked yesterday. So I don't have Your Honor's words from today exactly right, but I can draw from the way it was asked yesterday.
Go ahead, sir.
Yesterday, there was a question. There are several SPS witnesses that seem to say, oh, our credit rating is going to be damaged if you don't agree and give us what we want.
I'm sorry,
I'm
Mr.
going too fast.
Yes, sir. Yesterday, there was a question, and can you start again?
Starting again, there are several SPS witnesses that seem to say, oh, our credit rating is going to be damaged if you don't agree and give us what we want. But yet, when you look back, it doesn't seem as if when we give the parties what they want, there is any positive effect. The one time in recent memory when SPS didn't get what it wanted in the 17-00255 case, the commission gets blamed for the credit rating going down. I am having a difficult time finding out just where there's any positives to the commission other than the parties' positions give us what we want or the sky is going to fall. And I'll represent after that, there was some talk back and forth, but I want to pick up from there with the question, would you agree first that SPS did get its request in the 2019 rate case?
Yes, I agree.
SPS's requested ROE in that case was what approximately?
I'm stretching. Now I'm focused on what we're talking about here. I think it was a 9.45%.
I think that was the outcome. Do you recall what the requested ROE was?
I'm sorry, I don't.
Okay. Do you recall what the requested ROE was in this case?
10.35%.
And is that what is being proposed to the commission at this point?
No. 9.35% is the request.
If the commission were in a position where it was being asked by the parties hypothetically to grant a 10.35 rather than a 9.35, would that be viewed differently by the rating agencies?
Can you say that one more time, please?
Sure. If where we are, we're with a hypothetical stipulation that had SPS's original ask in the case of a 10.35 ROE, rather than the provisions that are in the stipulation, including a black box disallowance and a stated 9.35 for reconciliation statement and the wind project compliance purposes of a 9.35. would the rating agencies take a different view of approval of a stipulation that had one versus the other?
If I'm understanding your question correctly, sorry, maybe let me just answer it two ways. If the stipulation was asking for 10.35 and the decision was 9.35, I think, and everybody had agreed to 10.35. That's the important part of that. I think that would be seen as a negative, negative indication of support. If this particular stipulation is approved with the 9.35% ROE, as everyone has agreed to, I think that will be seen by the rating agencies as credit supportive, since we've reached an agreement among all parties that include the black box settlement to make some adjustments to capital structure and ROE. I think those are two different scenarios, so I'm not sure if I answered your question appropriately.
Yeah, let me try taking it out of hypothetical territory and ask this. Does it matter to the rating agencies not only that there was, take the last case, a stipulation that was accepted, but also what the contents of the stipulation are and how that impacts the revenue requirement, cash flow, and credit metrics of the utility?
Yes, it matters. I think that the rating agencies prefer as much transparency as possible. So if they can relatively understand the terms of the settlement, not only the revenue requirement, but if there are certain capital structure and ROE aspects of that, even if they apply to the calculation of the revenue requirement for the wind farm solely, I think that they prefer transparency, and that also nods to predictability and decision-making, which is what they're really looking for, consistency.
Or to get back to the question from yesterday, to actually get an upgrade, would SPS need a more positive set of contents of a stipulation than what was contained in the last case?
Yes, the decision that was made in the 2019 case, while it was indicated as credit positive, it really only allowed us to tread water in terms of our credit metrics and our credit rating. It did not do anything to improve our financial integrity. The stipulation in this case will definitely help support our current level of credit metrics, credit rating, and financial integrity. It's not going to do anything to move the credit metrics back to a higher rating, and that's not what we're asking for. We're asking to maintain our current situation.
And is that partly for both cases because the stipulations were the product of compromise with adverse parties rather than what SPS wanted, irrespective of that compromise?
That's correct.
Your Honor, other than the issue we discussed earlier, that was what I had for Ms. Martin.
Very well. So I believe then that now is an appropriate time for us to take our luncheon, and you can let me know whether or not you're prepared to address your issues 1 and 2 as discussed earlier in the context of Ms. Martin's testimony. So I won't excuse you yet, Ms. Martin, but I don't believe that there are questions for you subject to what happens after lunch. So I guess I would say you are at this point subject to recall. And trying to look ahead before we go, I know Mr. Du Bois, you indicated that Mr. Goodenough will be available this afternoon to answer the chairman's questions with regard to bench request 3. Is that correct?
Yes, Your Honor.
And are we getting him any earlier than 3, or is it going to be 3?
He can be available earlier than 3, Your Honor. If I know how much earlier, I think we can make sure we make that happen.
Well, depending on what you have to say after lunch, how about we have him after lunch?
Okay. Thank you, Your Honor.
Okay. And then we'll see. I do not have, I will make inquiry. I do not have questions for Mr. Mueller. And I want to move around the other 3 witnesses that you have proposed, and would like to have Mr. Matley available if there are no questions of Mr. Mueller after Mr. Goodenough.
Your Honor, just to make sure I have it straight, we'd be going after lunch. If there's, we'll see whether Ms. Martin is excused or not. I don't like being in the position of preventing a witness from being excused, but
Okay.
we'll figure out Ms. Martin, and then it would be Mr. Goodenough, Mr. Matley, and then we'd be on to Lytle and Cooley.
No, then we're going to go with Mr. Luth.
Oh,
And I believe I may want to save Mr. Berger and Mr. Lytle for in the morning, because I have questions of those witnesses. But I believe that Commissioner Hall may have questions for Mr. Cooley. And so I might be able, depending on how long Mr. Luth takes, we might be able to get Mr. Cooley in this afternoon.
okay. I'm sorry, just to
Okay.
make sure. So do I have it right then? Goodenough, Matley, Luth, potentially Cooley, Lytle, Berger.
Right. Yes.
Okay. Thank you, Your Honor.
Okay.
Madam Hearing Examiner,
Commissioner Hall.
I have not thought I would have any questions for Mr. Cooley at this point. Is that, you were mentioning you thought I had an interest in that witness? I don't believe I said that.
Yes. Yes, Commissioner Hall, it was my understanding, and I can be wrong, that you had some questions for Mr. Cooley with regard to talk. And
Oh, yes. Okay, fine.
Yeah.
Yes.
Yep.
I apologize. I forgot that.
Okay.
Yep. thank you.
And it actually may not be Mr. Cooley. I had asked this morning whether or not, I know Mr. Goodenough is going to talk about bench request 3, but I had asked who was the appropriate witness to find out about some compliance issues with regard to talk, I believe, as set forth in the 19170 case as they related to the new IRP filing. And Mr. Dubois, did you have I think that perhaps was the one that Mr. Marks had suggested that Ms. Weeks might be the witness for, but I was hedging my bets there that Mr. Cooley can also answer Tolk questions.
Your Honor, per our earlier discussion, I'm sorry I missed this when we were just going through lineup, but I think from the description I heard, I suspect Mr. Grant is probably the better person to be able to answer questions of the nature I was hearing. And I think we can pencil him back in to come back and see if he can address those anywhere in this lineup. And I might suggest it might make sense to do that sooner rather than later, because if it turns out I'm incorrect and he's not the person, then we'd still have the other witnesses not having already been on.
Okay. All right. Well, then, like say, let's go with Mr. Goodenough, Mr. Matley, Mr. Luth, and then if we have time at that point, bring Mr. Grant back. If we have time this afternoon, and then Mr. Cooley. I've not heard, and I do not believe, I'm going to check that that I have anything for like say Mr. Moeller or Mr. Martinez. So okay, well, if we've got all of that figured out now or not figured out, I'll be generous and let's come back at 1:30. Okay,
Thank
I
you,
have
Ron.
I have 12:24 right on my computer right now, but so we'll take an hour and just flipped over 12:25, an hour and 5 minutes for lunch. Thank you. We're recessed until 1:30.
Thank you.
And remember, the Zoom will stay live. So you want to mute and or
Leave.
not.
Desi knows you're sad. Joan,
Yes, sir. Hi.
those 3 exhibits, were they emailed or were they put in Dropbox?
They were emailed to the parties and the hearing examiner, and they were put in Dropbox. Do you want me to send them to you as well?
If you wouldn't mind.
Okay, hold on just a second. What's your email address?
Send it to Cumbre Court, CUMBRE
Uh-huh.
at Comcast.net.
At Comcast.net. Okay, I'll send it right now.
And these are the ones that are admitted, correct?
I'm sorry?
They are admitted, correct?
Yes, yes. So,
That's what I thought.
yeah, okay. I'll send
All right.
those to you right now.
Thanks, Joan.
Sure.
Ready when you are, Judge.
All right, Mr. Lee, thank you very much. Oh, we've got some people that dropped off.
I don't know if they would be trying to get back in, but you'd have to let them in.
Well, I'm not seeing anybody knocking on the door yet.
All right.
Okay. Well. Okay, well, I don't see anybody and it's time, so if you're ready, Mr. Lee, I am ready. And Mr. Du Bois.
Bill Du Bois for SPS. Thank you, Your Honor. Couple things. One is per our discussion earlier regarding recovery of power purchase agreement costs. I would specifically identify code 17.9.550.18 and 0.19 that govern prudence reviews and orders of refunds, respectively. Actually, I got them out of order. I think 0.18 covers refunds and 0.19 covers prudence review.
So then, Mr. Du Bois, you are asking me to take administrative notice of 17.9.550.18 and 19 in MAC regarding purchase power.
Regarding statements that were made by commissioners that utilities automatically are entitled to full recovery of PPAs without any potential review by the commission.
Okay, so you want me to take administrative review of those two sections of the administrative code that you're indicating have to do with purchase power agreement review?
Per our earlier discussion, obviously I take the view that the law is what it is on that
Okay.
front, but I think as we discussed, if it helps for clarity, then yes, taking notice of that would also be our request.
Okay, anybody object to me taking administrative notice of 17.9.550, 18 and 19 in MAC? Hearing no objection, I will take administrative notice of those sections. Anything else, sir?
Yes, Your Honor. While we're on that front, I had also referenced, and we might as well, I think, include that the commission had just issued an order along these lines in docket number 21-00046.
And what is that docket, sir?
In the matter of Southwestern Public Service Company's request for suspension of its fuel and purchased power cost adjustment clause, establishment of a regulatory asset. Oops, I may be reading the wrong case title. Sorry. Bear with me 1 second. No, that's actually the correct caption. I probably have to start over. In the matter of Southwestern Public Service Company's request for suspension of its fuel and purchased power cost adjustment clause, semicolon, establishment of a regulatory asset, semicolon, approval of a surcharge and a true-up mechanism. And the commission issued an order in that case on March 31st of 2021.
And you want me to
I
you want me to
suggest if
take
we're taking,
administrative notice of the whole docket, or you want me to take administrative notice of the commission's final order for what purpose?
honestly, I don't think we could take judicial notice of the whole docket, but I would suggest that taking judicial notice of that final order, along with the two rule references we discussed, goes further to that topic we were discussing of the fact that the commission does in fact review power purchase agreement costs.
Okay. Any objections to me taking administrative notice of the commission's final order in case number 21-00046, final order issued by the commission on March 31st? Hearing no objection, I will take administrative notice of that. Anything further, Mr. Dubois?
Yes, Your Honor, on our other topic, I have a proposed approach with respect to the EPE discussion.
And what is that?
First, we have circulated what we have marked as SPS Exhibit 54, which is a 3-page excerpt that I would represent as being from El Paso Electric Company's FERC Form 1 for the period ending Q4 2020. And if we could stipulate to the admission of that, and I can do some examination follow-up on with Ms. Martin on that, while also objecting to consideration of other material from El Paso Electric's docket or other matters outside of the record in this proceeding. That would be my proposed approach.
Well, that's pretty confusing to me, Mr. Du Bois. I mean, obviously, I'm only going to consider relevant evidence in this case. So tell me what you believe the relevance of SPS Exhibit 54 is.
I believe I can partially show a contrast from the characterization of El Paso Electric to SPS's circumstances. However, at the same time, I am limited in what fact material I have access to in order to respond to everything that was discussed as to El Paso Electric in terms of fact characterizations. And so that's why I'm breaking this into 2 pieces, where I think we can address a piece of this as to the comparison of the utilities' use of power purchase agreements and what relationship that may have in response to characterizations of that. However, I also don't have, as I pointed out before, the ability to do discovery or examine El Paso Electric with respect to other matters, such as their calculation of their capital structure and what may or may not have been included in that. And so I still have a record problem that I don't have a way to address on that, and so would object to consideration.
I'm sorry. I don't have a way to.
Object.
Proceed with respect to those matters, other than, I think, objecting to consideration of those matters. And I recognize, Your Honor, your statements as to your consideration in developing a recommended decision. However, I also have to be cognizant that that's not the final decision in the case. And that's why I would just ask to be able to make that objection in addition. And whether that's granted is obviously another thing, but I would ask to be able to offer those 2 pieces.
You know, I mean, Mr. Du Bois, I don't really want to introduce evidence generally that may not be relevant. I also do not want to introduce information from other commission cases that may or may not be relevant to this case. So number one is generally, I think we have enough issues in the case. And number two, like I say, I have a concern that introducing information about another utility that's not before the commission in this case might be inappropriate. However, that being said, and knowing that the commission is not strictly bound to the rules of evidence or civil procedure, and that in certain circumstances, the commission can admit information like hearsay and consider it as to whether it has weight, if any, in the proceeding. And if it is your belief that in order for the commission to comport with affording you appropriate due process in this case, I will allow you, if there's no objection, to use your purported Exhibit 54 and ask your witness questions to clarify for the commission EPE's position on the questions asked earlier this morning. So,
Thank you.
that being said, is there any objection to SPS using SPS Exhibit 45 entitled the FERC Financial Report Form Number 1, and the witness can further identify it? It says in period of report, end of fourth quarter 2020 for El Paso Electric Company. Okay, I don't hear any objection. Go ahead, Mr. Du Bois.
Thank you, Your Honor. Please, I would like to clarify that I share many of the points of view that Your Honor just expressed. The challenge is that we have from the commission statements as to facts, assertions of fact from outside of this case and with respect to El Paso Electric that were characterized as significant in the consideration of a commissioner. And so that's why I am proposing what I am proposing, notwithstanding my views of or belief that, and I will reiterate that we think that matters with respect to El Paso Electric that have already been stated as fact in this proceeding are outside of the record here, and I would not support their consideration. However, since that's where we are now, that's why I'm proposing what I'm proposing. So with
Very
that
well.
clarification.
Very well, and I've already set forth my position on what I consider, and as you pointed out, Mr. Du Bois, I am not the final decision maker. I'm just the hearing examiner, and I only offer a recommended decision and not a vote on the final decision. Go ahead, sir.
Thank you. I wouldn't say just the hearing examiner, but be that as it may. Ms. Martin, I am putting in front of you, with Your Honor's permission, what I'll characterize as a 3-page document that has a label added to it in the lower right-hand corner, Exhibit SPS 54. Do you see that?
I do.
And could you, for the record, identify what the title on the front is and what page numbers we are looking at?
Sure. The FERC financial report, FERC form number 1, annual report of major electric utilities, licensees and others, and supplemental form 3Q, quarterly financial report. And I was looking at page 1. It's for El Paso Electric Company.
And what other pages are included?
Page 69 and page 70.
And what is the year/period of report that is indicated?
Year period of report is end of 2020/Q4.
Thank you. And if you could please turn to what's provided as the second page of this. It's page number 69 in the lower right-hand corner. There's also an indication in the bar at the bottom, page 123.24.
I'm there.
Do you see a table on that page?
Yes. Under the section power purchase and sales contracts.
Okay. Could you please take a moment to look at that table? I see it's now also on the screen as well. So whenever you've had opportunity, please let me know.
I'm ready.
Okay. So a couple things I'd like to ask you about how the information is presented on here. Do you see in this table indications of the conclusion of the terms of the power purchase agreements that are listed?
Yes.
And that's the 4th column?
Yes, that's correct.
Okay. And are there any power purchase agreement terms that are set to conclude in the next year?
Yes.
What are those?
At the top of the chart, the purchase power and sale agreement for Freeport, it's the first and second line, look to be expiring at the end of 2021.
Okay. And do you see information here as to the commercial operation date of the various facilities and PPAs?
Yes, that's in the 5th column.
Okay. And for any of those, are those facilities that are not yet in commercial operation?
Yes, the lines, 1, 2, 3, the last 4 at the bottom of the chart, which would be for Buena Vista Energy Center, Hecate Energy Santa Teresa, Buena Vista Energy Center 2, and Hecate Energy Santa Teresa 2. It looks like they do not go into commercial operation until May 1st, 2022.
Thank you. And let me ask you, based on your knowledge of how the credit rating agencies look at utility obligations under PPAs, would a rating agency include consideration of a PPA that has for a facility that is not yet in commercial operation and therefore there isn't actually an active payment obligation?
No, they would not consider it until the time that that plant or plants are in commercial operation and there's an obligation.
And with respect to a PPA that is set to terminate in a, well, we'll use this specifically by December 2021 for a pair of PPAs of 125 megawatts, would that add how would the agencies look at that combination of termination date and size?
Sure. So the rating agencies take the net present value of all remaining payments and then discount that based on a risk factor as we discussed. So for the Freeport PPAs, since those are nearing the end of their date, without having any numbers in front of me, I would venture to guess that the amounts remaining under those PPAs are very small. And by the time they're discounted, they would not be material in terms of debt that the rating agencies are imputing onto EPE's balance sheet.
And thank you. And so once we take out things that the rating agencies wouldn't consider because they don't exist yet, and things that are, as you said, I won't put words in your mouth, but I'll roughly paraphrase a small remaining obligation on the first two. I think we're left with 1, 2, 3, 4, 5, 6 PPAs.
That's correct.
And what do you get as the megawatt capacity remaining from those?
Madam Executive Examiner, I want to object. So I think this witness has no direct personal knowledge of these facts. I think the testimony she's given about how the rating agencies might interpret certain facts is potentially relevant and within her knowledge, but she's testifying as to facts about EPE's PPAs that she has no knowledge of, and the document speaks for itself, but I don't think this witness has any foundation or any basis to actually attest that these PPAs exist or the dates or the sizes. And
well, this is kind of a different situation. It's not your witness, but I appreciate the point, Mr. Marks. Do you have a response, Mr. Du Bois, or do you understand that your witness may be getting away from what this document says?
Your Honor, I on the one hand, I understand Mr. Marks's point as to the witness's ability to speak to the reliability of this information or anything else about EPE. As we've talked about already, however, we are in a circumstance here where we've got fact assertions in the record also that I'm sorry, do not
But you don't have,
basis.
yes, Mr. Du Bois, but you don't have sworn testimony regarding assertions that may have been made. And I think, I think your witness can, I think Mr. Marks is right. So I'm going to sustain the objection to the extent that your witness can talk about information on this sheet, but she can't go beyond, for example, any other information unless she has an independent basis about EPE PPAs that she has that's not contained on the sheet.
If I could please ask the court reporter, did I have a question outstanding when Mr. Marks objected, and what was it?
Just a moment.
Thank you.
And what do you get as the megawatt capacity remaining from those?
So to be clear, Your Honor, my question was only asking for arithmetic based on what's on the page right here. Am I understanding correctly that the objection was sustained as to me asking that question, or is it as to broader matters?
And I thought that Mr. Marks was objecting to whether or not that was the total amount of PPAs that EPE might have had. Mr. Marks, was that your objection?
My objection would be resolved if Mr. Du Bois just asked his witness, prefaced everything based on what this exhibit says, how many megawatts are there, or what does this mean? But I feel like he's asking his witness to attest to the underlying facts, and she doesn't know whether or not this exhibit's accurate. So that was my objection. He was asking her, how many megawatts of PPAs does EPE have versus how many megawatts does this exhibit show EPE is having?
Right. And I think that was my understanding, that you were objecting to it in a broader context. So with that, Mr. Du Bois, if you'll just confine your questions to the document.
Thank you, Your Honor. I will try to rephrase. Ms. Martin, with respect to the 6 PPAs identified in this document that we have not already discussed, what do you calculate as the capacity of those 6 as listed here?
If I'm doing my math right, I get 107 megawatts.
Okay, thank you. Do you know what outstanding PPA obligations SPS has? Or what, I'm sorry, I phrased that poorly. Do you know the megawatt capacity of the PPA obligations that SPS has?
As I understand it from our IRP filing, that number is 2,444 megawatts.
Is it fair to say that's substantially more than what you calculated from the EPE document?
Yes.
And that, is it fair to say that would have different consequences in credit rating agency calculations for a utility that has 2,444 megawatts of capacity under PPA versus, whether it's EPE or not, a utility that has 107 megawatts of capacity under PPA?
I think that's a fair statement.
Thank you, Ms. Martin. Your Honor, I think that's about as far as I can get based on this document and the rulings that have been given.
Okay. And
And sorry, I will move SPS 54 into the record for the weight it
Mr. Du
deserves.
Bois, yeah, did you say where it came from?
This is, we would represent it to be a printout of the, from FERC of the filing of what's titled as the FERC Financial Report, FERC Form Number 1, Annual Report of Major Electric Utilities, Licensees, and other, and Supplemental Form 3Q, Quarterly Financial Report of El Paso Electric Company.
And it's only 2 pages of that report.
3 pages of that report, Your Honor, the title page and
Okay.
2 pages with contents.
Okay. Any objection to what's been identified as El Paso Exhibit 54, the EPE fourth quarter 2020, 3 pages of its FERC filing, FERC Form 1, and others as already read into the record? Hearing no objection. And for what weight, if any, it might be awarded, SPS Exhibit 54 is admitted. Mr. Du Bois.
That is what I had on those items, Your Honor, and for my part, unless there are other matters from Your Honor or from commissioners, I think we had, I've kind of lost the thread, but I think either Mr. Mueller, if there are questions, or Mr. Goodenough slated next.
Okay, were there any questions from anyone with regard to SPS Exhibit 54 before we leave? Hearing none. I think then that takes care of Ms. Martin's testimony. And Ms. Martin, you are excused.
Thank you for your time.
Thank you very much. And I believe is Mr. Du Bois, is Mr. Goodenough available now?
I believe so, Your Honor. Let me, if I may, step out for just a moment and make sure he's getting onto the Zoom.
Okay.
Thank you.
And just so people can be getting ready, Mr. Goodenough is going to talk about hearing bench request 3. Which was sent this morning. Oh, there he is.
Your Honor, I apologize. I'm not sure what's going on with Mr. Goodenough not appearing on.
He's-
Oh,
There he is. Hello,
I just
sir.
needed to apologize one more time.
There he is. Hi, Mr. Goodenough. How are you? Got to unmute.
That's right. It defaults to you. Good afternoon, Howard.
Good afternoon. Mr. Lee, would you swear in Mr. Goodenough, please?
Mr. Goodenough, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter not pending to be the truth, whole truth, and nothing but the truth?
I do.
Thank you, sir.
Mr. Goodenough, you
doing
prepared SPS bench request number 3? Can you hear me?
Yes.
Okay. Yes, you can hear me, or yes, you prepared SPS hearing bench request 3, or both.
Both. I can hear you and hear the request.
Okay, very well. Let me just get that up on the screen. Okay. And Chairman Fishman, I believe that you had questions. I will just say the bench request 3 said, please provide forecasted sales growth information included in SPS integrated resource plan. And there it is. Mr. Chairman.
Sure. Good afternoon, Mr. Goodenough.
Hello.
So I'm looking at the chart, and maybe you could just clarify a couple things for me to start. You've got 3 columns: planning forecast gigawatt hours, which I think is pretty straightforward. Is there anything that needs to be explained about that?
No.
Okay. Then we've got annual growth, and I'm interpreting that, and tell me if this is correct, as I would take year 2022 and divide by year 2021, and that would give me a percentage growth rate, essentially?
Yes, that's correct. The annual growth column is the 1-year growth rate.
Okay, great. And then the compound growth is basically recalculating that annual growth number cumulatively, so that if I look at 2041, it says 2.0% cumulative growth. That'd be kind of if I just amortize the growth over the whole period for all of
Yes.
these.
Yeah. So we've the forecast is averaging 2% growth per year over the period.
Okay.
I'm sorry, 2% growth per year and
Over the period.
thank you. If you could keep your voice up, sir, I'd appreciate it.
Will do. Thank you.
Okay. And have these
What
numbers?
is,
Go ahead. H.E. Hurst?
Just for clarification purposes, sir, what is over the period? What period?
Sure. Across the period on the page, so from 2021 to 2041.
Okay, so then, for example, where you have compound growth of 5.7% for year 2021, that's the growth that you anticipate from 2020 all the way compounded using up to 2040?
No, so the 5.7% in the compound growth from 2020 column for 2021, there's only 1 year of growth in that period. So that's
okay.
The annual growth rate in 2021.
Right.
For 2022, it would be the average growth over 2 years. 2023.
Oh, okay.
I'm sorry, sir. I'm sorry, sir. Could you say that again?
Yes. So for 2021, it is a 1 year growth rate. There's only 1 year in the period from 2020. For 2022, the 5.0% would be the average growth over 2 years, 2020 to 2022. Another example for 2023, the 3.9% is the average growth over 3 years, and then on down the line.
Okay. Thank you, sir. Go ahead, Mr. Chairman. Thank you.
Okay. From the 2018 IRP, first to clarify, my recollection is that there was never a formal commission approval. This had just been what had been submitted. Is that correct?
I'm not sure the answer to that.
Okay. I guess we can check on that with another witness. The 2021 IRP is currently being reviewed. Is that the status on that one?
That's correct. It was filed earlier this month.
Filed earlier this month. Okay, so under review. From the 2018 IRP to the 2021 IRP, the growth numbers go up. Could you just quickly explain why that's true, the major factors that contribute to that?
Sure. So there are three main factors that are contributing to the higher sales forecast and higher growth forecast as well. The first two impact what we call our base forecasts. So I will talk about those two factors first, give a little bit of an explanation how we go from the base forecast to this planning forecast that's shown here, and discuss.
Sorry, this base forecast to this?
To the planning forecast that is shown here.
Thank you.
And then discuss another driver of the increase in the planning forecast. The first and foremost, the main driver of higher load in the 2021 IRP is that we did not include in the 2018 IRP any assumptions of oil and gas expansion and the sales associated with the expansion of the oil and gas industry in New Mexico. Now, we did see expansion of the oil and gas industry in 2018, 2019, and to a lesser degree in 2020. It slowed down a bit, but there was still expansion. So the forecast itself is going to be higher just because we now have those 3 years of higher actuals due to that expansion of that industry. And also we are now including in our updated forecast, a short-term expansion of the oil and gas industry. So there's further growth compared to the prior forecast due to now incorporating some growth in that industry where we hadn't before.
I'm sorry, some growth in that industry and you trailed off.
Where we had not before. So
is that?
I'm sorry, go ahead.
Oh, I thought I saw you talking, but didn't hear you. I'm sorry. When we go beyond 2025, I'll just kind of pick that at random. We still see an extra around 1% a year increase in the total growth, even after that 2025 period. What drives that?
The driver there is a generally more positive economic outlook and more positive forecast for economic growth in our service territory
Okay,
in the 2018 forecast cycle.
okay. And I'm noticing in the numbers that the growth dropped significantly in 2023. Any particular event happening then?
Yes, the key event happening there is it's the way we're incorporating the growth of the oil and gas industry. We really do, kind of count on near-term growth there, but that we're not banking on growth beyond the next 3 or 4 years in that forecast.
Madam
Okay.
Hearing Examiner. Madam Hearing Examiner.
Yes,
I
yes, ma'am.
have a question. Commissioner Fishman just referred to a drop in 2023. So my question is, are you referring to the 2021 IRP? Because for the year 2023, there is not a drop.
I'm looking at 2021, the most recent.
IRP. Okay. Because the immediate previous testimony was about the 2018 IRP. So I was getting
Yeah.
confused.
I'm sorry
Okay.
if I was unclear.
Okay, thank you. So
Um,
we're still talking about 2021 IRP, correct?
Correct. And all my questions are going to be addressed to 2021, the most recent.
Okay, fine. Thank you.
Um,
Thank you, Madam Hearing Examiner.
Thank you.
And then so Mr. Goodenough, then in 2024 and 25, the number pops up again. And again, is there any particular thing that is driving that?
It would be the economic growth in the service territory driving that.
Okay, long-term economic growth. And those projections come from where?
We get those from an external vendor, IHS Market.
I'm sorry, the name?
IHS Market, and that's MARKIT.
Okay, are there any other things that we should know about this chart?
Sure, I'll share the other key driver of what's increasing the forecast, if you'd like to hear it. So the driver is in the 2021 IRP, we're now assuming a faster pace of electric vehicle adoption than we did in the 2018 IRP.
Okay.
That doesn't necessarily impact the next 5 years or so all that much, but once we get up past 2030, we start to see that impact as well.
Okay, so long term, your thought is that electrification policies will have an impact.
That's correct.
Okay. I don't have any further questions about it. Thank you.
Thank you.
Do you want to follow up, Mr. Du Bois?
No, thank you, Your Honor.
Okay. Do we want to offer the hearing third bench request into our record? Is there any objection? Hearing none, SPS third hearing bench request response is admitted. Okay. And what happened to me?
Massive.
I've disappeared. The Zoom does not like me yesterday it didn't like me messing with the Dropbox. And today it doesn't like me touching the email. Okay, very well. So, Mr. Goodenough, thank you very much for appearing here today and for responding to bench request 3. And you are excused, sir.
Thank you. Have a great afternoon.
Thank you. Okay, I believe now in our order of things, Mr. Du Bois, we are going to go to Mr. Matley.
Okay, Your Honor, can I ask, is Mr. Mueller
Oh,
excused?
sorry.
or-
Let's back up. Let's go ahead and do that. You're correct, Mr. Du Bois. Thank you. Did anyone have any questions of Mr. Mueller? I have none. I'm not hearing that anyone else does. So Mr. Mueller is excused. And now can we call Mr. Matley? And I'd like for you to identify for me, Mr. Du Bois, when the email was sent that has the changes to the testimony.
Okay, we can bring Mr. Matley in and I will get that answered for Your Honor.
Okay. I don't know if it was yesterday or Sunday.
Days are blurring, at least for me, Your Honor.
Well, I just want to make sure, and that's the downside of using this Dropbox, is that I'm going to send the changed exhibits to, and the new exhibits to the court reporter via email. And I believe the non-conforming exhibits still in the Dropbox still have Miss Niemi's name on them. So that's why I wanted to know when the email got sent for that had Mr. Matley's information.
Yes, Your Honor. And
Okay, well, Mr. Du Bois is looking. Mr. Lee, would you like to swear in Mr. Matley? Good afternoon, sir.
Good afternoon.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
How we doing, Mr. Du Bois?
My email is frozen, Your Honor.
We hate it when that happens.
Yes, we sure do. May I have a minute, please?
Let's see.
I apologize.
Could it have been Friday?
I don't think it was, Your Honor. I apologize. Can I have a minute? May I step away for a moment, Your Honor?
Sure.
Thank you.
Okay, don't be locking the door there, Mr. Matley.
I would not do that.
I didn't think you would, but you know, little levity never hurts. Well, I can't find it and I've looked twice. So hopefully Mr. Du Bois will put in a call to Mr. Settles, who knows all documents, and we'll find that out.
Could you spell settles?
SETTLES.
Thank you.
Uh-huh. You need a document from SPS, Mr. Settles is the one.
Your Honor, so the motion was filed Friday. They were uploaded to the Dropbox yesterday. However, I apologize, they had not been circulated by email, and that is happening right now.
Okay.
Not by me, though.
Probably by Mr. Settles, who I was just complimenting.
Rightly so, Your Honor. Thank you.
Well, while we're waiting to get that, because I want to have that before I ask the questions that I have. Let's go on to another procedural issue. I indicated this morning that I wanted parties to look through what I downloaded to the Dropbox this morning. Were the commission exhibits at the request of Chairman Fishman, that being the responses to his bench requests, which were labeled as commission exhibits 4 through 28. And you know, I'm hoping parties have an opportunity to look those over, because I'm going to ask you tomorrow. We'll go through them, and I'm going to want to know whether or not there's going to be any objection or other comment on those 24 items. Okay, well, I don't see anything yet. Don't want to waste time. Good afternoon, Mr. Matley. How are you?
I'm well, thank you, Your Honor.
How was vacation?
It was lovely.
I hope it was over before they called you into service.
I was planning to be back on Monday in a slightly different capacity, but I'm happy to be here.
There you go. Well, obviously we have concerns for Miss Niemi, but we're happy to welcome you, Mr. Matley. My understanding is that you assisted and or helped to prepare the cost of service study for SPS in this case?
That's correct. I assisted Ms. Nemi. I prepared the cost of service and helped to prepare the cost of service since the start of the case. So I'm quite familiar with it.
And are you an SPS witness or employee or an Excel employee?
I'm an Xcel Energy employee.
Okay, and in the hierarchy of Excel land, how does your position relate to, or does it relate to Miss Niemi?
Ms. Nemi is my boss, my manager. So
Okay.
We are quite close in hierarchy.
Okay. And close enough that you feel comfortable in adopting her pre-filed direct testimony, her rebuttal testimony, and her testimony in support of the stipulation?
I do, Your Honor.
Okay. And including her errata to attachments 12A and 12B to her direct testimony. Correct?
Yes, that's correct.
Okay. So then basically your testimony is now SPS exhibits 21, 22, 23, and 24, correct?
Correct.
And I just need to grab one more notebook. That's a problem with being evicted from your office. You don't have a big desk to, looks like you have a table. Of course, you do have to share it, right, Mr. Matley?
I do. I do.
And I think I'm pretty familiar with Miss, is it, I keep calling it Niemi. Is it Ni? Is it pronounced differently?
It's pronounced Nimi.
Nimi. I'll try to remember that. Ms. Nimi's testimony, now your testimony, and having seen cost of service studies before, and it looks like, Mr. Matley, that on page 4 of your now direct testimony, at lines, well, you're giving a summary, beginning on page 4, line 8, that says that you're recommending that the commission approve the SPS request at a level sufficient to recover an overall revenue requirement for the New Mexico retail jurisdiction of $410,824,970. Correct?
That's correct.
And then if you move on to the next page, it says the revenue requirement reflects an increase in base rates of $87,782,544. Correct?
That's correct.
Okay. Don't just round those off to 50.
We prefer to be precise.
Excellent. And as you know, in your stipulation testimony, that is not the revenue increase that was agreed upon, was it?
It was not.
And as a matter of fact, you're referring it on page 10 and 11 to the table in stip-1.
Yes, I see that.
Okay, which I'm actually going to look at. I'm actually going to look at Exhibit A, page 1 of 7. which is your settlement rate designed by class, just to get the number. And it's showing a base rate increase of 62,423,333. Is that correct?
Let me just find that table. Yes, that's correct.
Okay, so not trying to be imprecise, but just sort of giving it the eyeball look from one book to another, going from 87.8 to 62.5. If I get out my abacus, looks like about 25.5 million.
That's right. I would agree with that.
And so in there we go. In finance terms, and I see now that you are the manager of revenue analysis. A $25 million reduction from 87.8. Do you consider that? How?
I would characterize that as a significant reduction from our initial request. And maybe, I don't know that it's that relevant, but just to clarify, I believe it's Ms. Nimi's title that's manager of revenue analysis. My title is principal rate analyst.
Principal rate analyst. Okay. All right. Well, I was just looking at oh, I see. That's why the red line is through there. It's like, wait a minute, why don't you tell me about your background, Mr. Matley? Since I was waiting to testament supplement, maybe it's in there. Is this you? You graduated from University of Pennsylvania with a Bachelor of
Yes.
Science degree in chemical engineering?
That's
That
correct.
is you.
That is me.
And you became a principal rate analyst with chemical engineering?
I did. It's maybe not the traditional path, but it's the one I found myself on.
Okay.
Certainly provides a quantitative background, although I've not engineered any chemicals in a long time.
Yeah. seems like you'd have more fun things to, I don't know, interact with, you know, chemicals and test tubes and all kinds of machines and no,
Perhaps. I'm
perhaps.
quite enjoying
Okay.
myself in this case, though.
Okay, well, that's good. It's good to enjoy what you do. Absolutely. So if you can direct yourself to your new testimony at page 30, and you are on page 29. The question is posed, what adjustments did you make to the ADIT balances included in the base period rate base? And ADIT is a tax issue, correct?
Yeah, that would be accumulated deferred income tax, the difference between the book tax that we pay and the tax calculated for regulatory purposes based on straight line depreciation.
And you're referring to Ms. Koch's testimony in answering that question on page 30, beginning at line 8, as discussed by Ms. Koch in previous years, SPS has been allowed to take additional tax depreciation expense as a result of bonus tax depreciation, which resulted in more tax deductions than SPS could use. In other words, SPS had more tax deductions than taxable income, which results in a tax NOL, N-O-L. What is a NOL, Mr.
That
Matlow?
stands for net operating loss,
Okay.
which is the remainder of the tax benefit after all of it's been used to offset taxable income.
And then you say, because SPS was in a NOL position and could not use all the tax deductions, a deferred tax asset was created and included in rate base to offset the ADIT balances that decreased, and then in parenthesis became more negative as a result of bonus depreciation. Correct?
That's correct.
Okay, so as a non-tax person and someone who fits into that category, if I had been better in math, I'd be a doctor. What does SPS having too many tax deductions and not being able to use them mean practically?
Well, practically speaking, if you cannot use all of the tax deductions that you have, then you are also allowed to carry them forward to future periods. So those.
You don't just lose them?
Nope. You do not lose them. You can retain the benefits. There are rules about what you can retain, the length of time for which you can retain it. That's, I would say, as much as I know on that particular topic, and any more kind of in-depth understanding of the rules around NOL accounting is probably best for Miss Naomi Koch. But you can roll forward those NOL benefits to future periods and offset future tax liabilities.
And so why couldn't you use them?
There's not enough taxable income to offset. So, maybe another way of saying it is there's more NOL tax deductions than we have available tax to offset.
And I was also interested, sir, in the testimony at page 57 and 58. The question posed at lines 10 and 11. Please discuss the adjustment for reversing the Texas deferrals associated with COVID-19 expenses.
Yes, I see that.
And the ultimate bottom line on page 58 at lines 5 through 7 say, therefore, it is appropriate to reverse the Texas COVID-19 expense deferrals so that the appropriate amount is allocated to New Mexico. So I see the result, but I'm just wondering what happened in Texas that your Texas jurisdiction that has an effect on your New Mexico jurisdiction.
Sure. So in our Texas jurisdiction, they issued an order on March 26th, 2020, allowing SBS to defer certain costs associated with the COVID-19 pandemic. That deferral is happening on an SPS total company basis. So as those costs are deferred, they're not showing up, in the historic test year in our books and records. So the reversal of that deferral, in effect, adds back those costs on a total company basis, of which the New Mexico allocated portion sort of goes into our cost of service.
So through a Texas order, you deferred expenses that would have been allocated to New Mexico?
Yes.
And then you're adding them back because the order expired?
No, we're adding them back because there's no comparable order in New Mexico. And the effect of adding those costs back is as if there was no deferral order at all. And we just accrued those costs in the normal course of business, which we did.
But if you didn't have an order from New Mexico, why did you defer them at all?
The costs are deferred on a total company basis as we incur them, because the allocation of costs really only happens in the jurisdictional cost of service. So when we have the deferral order, we have to defer all costs.
Okay. And I'd like you to look at the errata to the 12A and 12B of the direct testimony. And my understanding is that if you look at page 84 of your direct testimony, the question posed at line 1 through 3 says, Mr. Grant discusses the implementation of the settlement in case number 17-00044 UT. Are you sponsoring any calculations necessary for the implementation of that settlement? And then at line 4, you begin your answer and you say, yes, I have calculated the revenue requirement for the Sagamore and Hale wind projects, which will be used to calculate any credits to customers consistent with the terms of the settlement. I present the Sagamore and Hale revenue requirements in attachments 12A and 12B on a dollars per megawatt hour or MWH basis. That's your testimony, sir?
That is.
Okay. And later on in the page, the question posed at line 15 and 16, what generation amount did you use to calculate the revenue requirement to a dollars per megawatt hour figure? And then you answer at line 17 and 18, I used a generation amount of 576,598 megawatt hours, which is the New Mexico retail allocated share of total generation of 2,009,894 megawatt hours. Is that correct?
That's correct.
And then you say the total generation amount is based on a capacity size of, and this is on page 85, of 478 megawatts and a capacity factor of 48%. Correct?
That's correct.
Okay. And those numbers are for both, correct?
I'm sorry, could you repeat that?
Yeah, the numbers that you came up with and the megawatt hours, in that question and that capacity size of 478 megawatts, that's for a combination of Hale and Sagamore?
No, 478 megawatts would be just one of the two wind projects.
So this is just for Sagamore.
I am trying to check that right now. Unfortunately, I don't have the errata version.
But Your Honor, I'm showing we were missing a page for Mr. Matley. I'm showing him that page.
Oh, okay. I was going to say I can.
Okay, I've got it. So 478 megawatts is the Hale wind project. And in fact, this entire Q&A refers to the Hale project.
Madam Hearing Examiner.
Are you sure? I mean, the heading on page 84 says Sagamore and Hale.
Yes, I see the heading. I'm looking at, at the bottom of the errata version of attachments 12A and 12B.
Oh yeah, I see that too.
Those calculations are shown.
Yeah, hang on, let me get that.
Madam Hearing Examiner, what document are we looking at?
Hang on one second, Commissioner Hall. Let me get, I'm trying to. There we go, Commissioner Hall. What we're looking at is the errata. This is entitled SPS Exhibit 22. And this is the errata to Schedules 12A and 12B of the direct testimony
Of whom?
for Mr. Matley, who has adopted Miss Niemi testimony.
Oh, I
She
see.
had
Are
a-
we using the NEMI, are we using the NEMI testimony then? I don't find that Matley in the, I haven't found Matley in the docket.
It just got emailed, Commissioner, and I've got the,
Did you email it out to everybody?
well, they just emailed it out just now. I'll be happy to.
Who does it come from?
SPS.
I'm not finding it in my inbox.
There you
Probably-
go.
Thank you.
Uh-huh. So
Let's see.
this is,
I don't have it yet. Did you just send it to me?
I've got it up on the share screen,
Oh,
the document I'm talking about,
yeah, okay.
and I just emailed it to you.
Thank you.
And Mr. Matley, Miss Nimi had a medical emergency that I was informed of Thursday, and I was informed that Mr. Matley would be adopting her testimony on Friday. And so, okay, do you see the exhibit, Commissioner Hall?
Yes, I see it. Thank you.
Okay. Uh-huh. So when we look at page 1 of 1, down there near the bottom, the 2,009,894 megawatts refers to hail only. Is that what you're saying?
That's correct. That's what I'm saying.
Well, if you go on to the second page, do you not, why didn't you go ahead and include the Sagamore information?
So that is the Sagamore information listed there. And we may have inadvertently omitted that from the testimony.
Well, are any of the numbers that, I guess more importantly, were the Sagamore numbers inadvertently admitted from the calculation?
No. Those are the Sagamore numbers on that attachment, and that is the calculated Sagamore revenue requirement of at the bottom, shown in line 60. And so those are the Sagamore numbers. They're just not reflected in the testimony itself.
Okay. And so for what period of time is that 576,598 megawatt hour figure for?
That's for a year. 1 calendar year of operation.
What? Want me to get it?
Okay, Commissioner, I can hear you.
It's David Aragon.
Commissioner, I can hear you.
Hi, it's Cynthia. I'm getting the phone. But I'll hand it to your
You might
mom.
want to mute yourself,
Yes.
Commissioner.
Yeah.
Commissioner Hall,
Yes? Oh, sorry.
I can hear you.
I am so sorry.
Okay. So where do we get the 5,700, 500, let me try again. 576,598 megawatt hours. Where is that on this chart?
Believe you're looking at the Sagamore revenue requirement, so it's up on the previous page of this attachment, attachment 12A.
But
So if you scroll down, yes, the applicable generation number is actually, if you look on line 58.
Yep.
So we're taking the total generation and we're just using the energy allocator to allocate it to the jurisdiction.
Okay.
It's 659,446.
I'm sorry, the
And
number
what-
again, it's
659,446. And I believe when we filed that errata testimony, we also crossed out or redlined this Q&A that we're discussing.
Okay.
And so that 576,000 number that we were discussing is not accurate. It's that 600,000 number in the errata attachment.
Well, I'm looking at the errata and I don't see that it changes that number. Oh. Also striking the question and answer on page 84. Line 15. Yep, you're right, Mr. Matley. And so then where are you putting in the corrected information?
So the corrected information is in the corrected attachments that we were just reviewing.
But how am I going to know that if you don't do a Q&A that tells me? Okay, so my new number is in line 58 and it is the 659,446.
That's correct. And that leads to the Hale revenue requirement in the New Mexico jurisdiction of $46.12 per megawatt hour.
Okay. Which is like over $10 higher than the comparable Sagamore. Isn't it?
I believe Sagamore's about $10 higher than Hale.
Do you know why?
I do not know the details of why that's higher.
Okay. I think I'm going to be talking with Mr. Lytle about that. So I don't think don't think I had any rebuttal questions. Oh, and I'm just going to kick myself. Okay, ouch. I just kicked myself for asking you this, Mr. Matley. I don't know. I got to, so that's just the way it goes. If you look at page 13 of your testimony in support of the stipulation, you are referring back to a question on page 12, lines 14 through 17. The question says, Mr. Grant discusses in his testimony what earned return on equity, ROE, would result from applying the revenue requirement and depreciation, in this case, to SPS 2020 actuals. Did you perform that calculation? And your testimony was, yes, I did. Is that correct?
That's correct. I did.
Okay. And then on page 13, you say, please explain your methodology. It's nice when you get to ask yourself the question that you want to answer, isn't it? kind of fun. So then you answer, beginning at line 2, I revised SPS's 2020 actuals to include assumed additional revenues of $62,423,334, which you have in parenthesis is the amount contained in the stipulation. So that's the revenue that we've already talked about, right?
That's
revenue
correct.
increase.
That's the
that
revenue
results-
increase.
Been agreed
been
to
agreed
in the
to.
stipulation. Okay.
Yes.
Okay, as well as adjusted the depreciation expense awards upwards by 29,685,000.
I'm sorry, Judge. I just had a blip on my machine. Can you ask the question again?
Sure. As well as the adjusted depreciation expense upwards by $29,685,286 to reflect the full impact of the depreciation, annualization, and new depreciation rates from the stipulation for a net change of $32,738,048 to the 2020 actuals. That's your testimony?
That is.
Okay. And then here's the next part. At line
Hearing
6,
examiner, excuse me, which document is this?
this is the uncontested stipulation testimony of Mr. Matley.
And this is something you emailed to me?
Yes, ma'am.
Okay. Is it
It
21?
is SPS Exhibit 22.
Oh, okay. Thanks. Got it. Sorry to interrupt. Go ahead.
Okay. Is it on the screen?
Yeah. Oh, well, I've got it as well.
Okay.
I mean, I'm opening up what you've emailed me so I can look at it.
Okay. So at line 6, it says SPS's actual earned
What page are
RO
you on?
ROE, page 13,
Thank you.
was 6.18%. That's what you testified to?
That is.
Okay, so what is an actual earned ROE?
An actual earned ROE is when we take a look back at 2020 actuals. So we use, we develop a cost of service based upon what actually happened in calendar year 2020. So we use actual expenses, we use actual rate base amounts, as of December 2020 for most categories. Some rate base items are 13-month averages. And we calculate the revenue requirement and the revenue deficiency or excess. And we therefore, based upon those numbers, calculate the earned return on equity that actually happened in calendar year 2020.
Okay. And then further, the question posed at lines 11 and 12, to be clear, does the outcome of the present case have any actual impact on SPS's 2020 earned ROE? And you answer, no, it doesn't. Why is that?
Well, what we're doing in this calculation is taking the results of this settlement, which is forward-looking. It's what will happen if the settlement is approved. We're applying those back to 2020 actuals. So 2020, what happened is what happened, and the earned ROE was 6.18%. The outcome of this case and this settlement won't change that. It will change future earned ROEs.
But are there any decisions that are made in this stipulation that affect actual amounts at 2020 actuals?
I don't believe there are, or at least there are no decisions I can think of that would have a backward-looking impact into 2020.
Okay. All right, sir. I appreciate it. Does anyone have any questions for Mr. Matley? Okay, I'm not hearing that anyone does. Does anyone have an objection to what has been identified as SPS Exhibit 21, the direct testimony of Ryan A. Matley to replace S. in NEMI? SPS Exhibit 22, Ryan A. Matley's replacement errata notice regarding schedule attachment S in N12A and B to the direct testimony of S in NEMI. SPS Exhibit 23, the rebuttal testimony of Ryan A. Matley to replace S in NEMI's. Or SPS Exhibit 24, the testimony of Ryan A. Matley to support the stipulation replacing S in NEMI. Hearing no objection, SPS Exhibits 21, 22, 23, and 24 will be admitted. Okay. I think now might be the appropriate time for us to take a 10-minute break. We will have a recess until 3:30, and then I believe I believe Mr. Dubois that Mr. Luth is your next witness.
I believe that had been the guidance, and he certainly can be, Your Honor. I a little bit lost the thread on whether it was Luke or Grant, but.
Oh, do you
I
have
understand
Mr. Grant?
this is-
Yeah,
I think
let's,
it can be either, Your Honor, I
Okay.
believe.
all right, Mr. Matley, you're excused. Thank you very much, sir. And appreciate it. And let's have Mr. Grant back at 3:30.
Thank you.
Okay,
Thank you.
we're recessed. Mhm.
I'm ready, Judge. You're on mute, Judge.
Thank you, sir. I'm happy to report it's raining. Finally at my house.
We have some menacing looking clouds, but that's about it.
Well, enough to have to move the hummingbird feeders inside the portal. So if all of a sudden you don't see me, it means my electricity has gone off, which it is prone to do. Okay, we're back from our recess. And I believe, hello there, Mr. Grant.
Good afternoon.
Thanks for coming back.
Oh, no problem. My pleasure.
And Mr. Grant is going to answer those questions on
And we just lost the judge. I'm going off the record. For those of you who were listening, the judge warned us this might happen if her power goes off.
Yeah, I'm hearing thunder and there looks like there's a big storm over Santa Fe right now.
Hello.
Hello, Judge. I
Long
went off the record.
Thank you. Interesting how I predicted that, huh?
Yes, ma'am.
Yeah, it was a big, long clap of thunder. I thought, uh-oh, well, we know what might be happening now. Okay, well, I'm back. And where's SPS? There's SPS. Hello again, Mr. Grant.
Good afternoon.
Okay, well,
I think we may have lost the judge again.
I believe you're back to see us, Mr. Grant, to answer questions about the IRP.
Yeah, I think it had to, my understanding from what I heard, it had to do with our compliance to whether we met our compliance obligations.
Okay, and I think Commissioner Hall, you had questions for Mr. Grant. Go ahead and unmute yourself.
Sorry. Yes, I do. Yes, I'd just like to ask a few questions about that. I was looking at the old stipulation last night and can I just proceed?
Yes, please.
Okay. Well, good afternoon, Mr. Grant. Nice to see you.
Good afternoon.
As I say, I was looking at the old stipulation last night. Well, that is the one from the 19-00170-UT case. It's the uncontested comprehensive stipulation. And from looking at your testimony, it definitely looks like you're committing to retirement of the plant in 2032 and converting it to, I was just looking at it, it's on my computer, to synchronous condensers using to provide voltage support. Is that correct?
A little correction. We are proposing that the generating capability will cease operations in 2032. The synchronous condensers, the capability to operate that unit of synchronous condensers has already been done. We can operate those facilities in synchronous condenser mode when it's not being utilized or called upon to generate electricity today.
Okay, that's, by the way, I think that's really great. What I wanted to ask about was there was some more specifications in this stipulation. It said SPS will submit a robust analysis of total abandonment and potential means of replacement by June 2021. This may have all been overtaken by events, but I just wanted to ask, what of these provisions, besides an analysis of replacement, it includes provisions about an independent evaluator, and that this analysis should be incorporated in Southwest Power Services 2021 Integrated Resource Plan application.
I'm sorry, should be incorporated in
the Southwest, in the SPS's 2021 Integrated Resources Plan application. And it shall include, without limitation, replacement resources priced based on RFP or RFI process and the value of reselling the water rights. Did that happen, or are you guys planning to do that, or where are you on compliance with that?
Yes, Commissioner and Madam Hearing Examiner, we did follow our TOC analysis I'm not going to just call it token analysis because one of the scenarios actually looked at Harrington as well on June 30th of this year. We are in the process of the parties that were interested in that case giving us some feedback from the results of that study. So that's a work in progress. We did go ahead and file our IRP on June the 16th and incorporated, on a high level, what our plans for token Harrington at this point in time. One of the things I will tell you is that there was a lot of information in that the results of the study that we are still in the process of analyzing since we've had the results, right at 30 days today, but we've had the results for that study for a month now.
Great. I'm very glad to hear it. Thank you so much. Will you be holding technical conferences? This also says in the IRP public input process and prior to filing the IRP, SPS shall hold 2 technical conferences located in either Santa Fe or Albuquerque.
Yes, Commissioner Hall, we, because of COVID, we did hold the technical conferences, but they were on video calls because of the inability to meet in Santa Fe during the time frame the study was being. We also had some other meetings when we were, talking about other issues. So we had 2 technical conferences, but we actually had more meetings than that with the counterparties. And I don't think we're stopping there. I think the parties are still able to provide comments to our study. Matter of fact, if I'm not mistaken, we are looking at some things that have been identified that we're looking at as well right now. So it's going to be a work in progress. But we did comply with the stipulation holding the technical conferences. We did use an independent evaluator that signed off on the process, and we did hold the technical conferences as required.
Well, excellent. Thank you. That's really all I wanted to know. And you were suggested as the right witness to question. So I guess they brought you back for this brief period of time, and I appreciate it. But I appreciate what you guys have done with Tolk. So thanks very much.
Are you saying Harrington, Mr. Grant? Harrington?
Yes, we did a sensitivity on Harrington that we did an analysis on as well. As part of one of the scenarios that we had to do was whether we could retire all coal units earlier, and that was one of the scenarios.
That's right. Sorry, I did see reference to Harrington. So in this case's proposed stipulation, it does have the provision of Harrington that it will cease the use of and retire its coal facilities by the end of 2024. So you say you did a sensitivity on it in advance. Was that in the context of the Tolk analysis as well, or separate?
We've been working on that, but it was one of the scenarios that we also studied and as we had committed to in the previous docket. Okay,
so I'll find that in the Tolk filing that you made in the end of June.
Yes, the analysis is public. Like I said, we're still soliciting input from the parties. So depending on how that process goes, we may be incorporating some of those comments.
Okay. Well, fine. Thank you very much. That's pretty much all I had to ask. Thank you very much, Mr. Grant, and thank you, Madam Hearing Examiner.
Thank you, Commissioner Hall. Thank you, Mr. Grant. Any follow-up or questions? Mr. Marks?
This is Mr. Marks, and Mr. Grant, I think you covered partly covered the question I was going to ask at the very end of your responses to Commissioner Hall. As you indicated, you're in discussions with parties. I know you're in discussion with my client Sierra Club, and there are some things that may need to be corrected or refined in the Tolkien analysis. Would you agree?
Yeah, my understanding, one issue has been identified that we are looking at and agree that, and if I'm not mistaken, they were O&M cost, that if you run it over a 10-year period, it matches out, but it was heavily loaded towards the first 5 years, and that's being levelized out over 10 years. And what we're seeing is that doesn't necessarily make a big change in the outcome, but it's going to be things like that, as you know, Mr. Marks, on any study like that. You know, you have to look at all the inputs and outputs and make sure that you agree with what they were, and that's what we're in the process with.
Okay. Yeah. Are you also aware that it appears that the maintenance capital streams and the water well streams for some of the scenarios are not correct?
Yeah, and I said O&M. I should have said CapEx. Mr.
Okay.
Marks, you're correct. It's some of the capital adjustments in that.
And certainly, I appreciate the way you describe the process as collaborative and transparent with parties that are interested. So my question is, will there be a follow-up filing that either changes the results or informs the commission that you looked at these things and it doesn't materially affect the action plan? So will there be a filing?
Mr. Marks, I think if anything else, there ought to be at least an informational filing to change any, specifically if what we determine is there's any substantive change. I think I don't mind committing to at least an informational filing. But as you will know, there's a lot of information at IRP, and one of the things I like about the company I work for is, you know, we need to analyze that data and see how much of, you know, some of that data is actionable and where we need to go from here. A lot of things are happening in Washington that might change some of the results of that study, as you will know. But we need to look at what that study is telling us and analyze it and see where we go from here.
Okay.
Did he say CapEx, Mr. Marks?
He's CAPEX. That's I guess it's a portmanteau for capital expenditures. Don't
That's
ask
correct.
me to spell portmanteau though.
That's good. Thank you.
Anything further, Mr. Marks?
Mr. Grant, would you commit that interested parties?
I think you're getting a little far
Okay.
afield of the
Yeah.
reason,
Withdrawn.
Mr. Grant. Okay. Okay.
Ma-
Any
Madam-
follow-up?
Madam Hearing Examiner, I guess I do have, I apologize, I missed one bullet here. In the previous, in the STIP arising from the case 19-00170, there's a bullet here that says, I mean, it's a sentence that says, SPS also commits to running at least one scenario in which all of SPS's coal burning units are retired or replaced.
I'm sorry, Commissioner. Can you start that again? SPS also.
Yes. SPS also commits to running at least one scenario in which all of SPS's coal burning units are retired or replaced before 2030. Is that part of your analysis, Mr. Grant?
Yes, I don't want to misstate, but if I'm not mistaken, there were 6 scenarios in the study, and retiring all the plants I believe the year was 2023 was one of the scenarios that we analyzed.
Okay, it says here 2030, but if 2023 is sooner, that's fine.
Yeah, it was prior to 2030. Yes, that's correct.
Yeah. Okay, excellent. And it says the evaluation shall use the type, technical characteristics, and cost of the resources needed or available to replace the capacity provided by TOLC, the economically optimal abandonment dates in terms of the public interest, and the impact on customer rates of multiple abandonment scenarios based on the present value revenue requirements considering SPS's integrated resources. So I assume you are following those dictates in the analysis as well, correct?
Yes, Commissioner. We are.
Okay. Okay, great. Thanks very much. And I appreciate Mr. Marks asking about a subsequent filing too. But it seems kind of inherent in this whole thing that you would file your analysis. So you will be filing, correct? I think that's what you told Mr. Marks, right?
Commissioner, I'm getting an echo. I guess somebody turned up their sound. One of the things I think we can't commit to any changes that we make on the study. We can do at a bare minimum an informational filing on the impact that those changes made.
Okay. All right. Thank you very much. So, Madam Hearing Examiner, I have no more questions of this witness.
Very well. Thank you. Thank you, Commissioner Hall. Any follow-up, Mr. Du Bois?
No, thank you, Your Honor.
Okay. Thank you, Mr. Grant, for coming back. You are excused.
Thank you.
Okay. And I just wanted to know if, because I don't want to forget about it, but SPS did in fact submit information this morning to bench request, hearing bench request 4, and that was, please provide criteria that explains more information on how the credit rating agencies rate particular actions by commissions. And there was a response from Mr. Shipman, an attachment. And is there any objection to admitting hearing bench request 4? And hearing no objection, hearing bench request 4 will be admitted. And Mr. Shipman, you are excused. Okay, I believe, Mr. Du Bois, that our next witness is Mr. Luth.
Yes, Your Honor, we'll have him in just a moment.
Okay.
You can be either. People think outside.
Good afternoon, Mr. Luth.
Good afternoon.
Mr. Lee, would you swear in Mr. Luth?
Mr. Luth, would you raise your right hand, please? You solemnly swear the testimony you're about to give, no matter not opinion, should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Thank you. And Mr. Chairman, I believe you had some questions for Mr. Luth. You're
on mute.
You're on mute.
That's the most popular phrase in the nation these days. Welcome, Mr. Luth. I'm going to be kind of big picture here in my questions, not delving into a lot of technical details. So I had expressed at the beginning of the hearing that I had some concern with the stipulated rate increases that are 10.84% for residences and for large general transmission, 1.48% decrease. And I'm concerned that the revenue increase is being maybe borne too heavily by residential customers. So that's where I'm coming from when I ask these questions. And first of all, I'm looking at the last rate case. And I'm noticing there that the increase on total revenues, when I look at base rate plus fuel savings, so it's after the fuel savings component is included, that the rate changes stay in a pretty narrow range, pretty much 2% to 5%, give or take, and that residential had a 3.53% increase.
Excuse me, Madam Hearing Examiner and Steve.
Yes.
Commissioner Fishman, where are you reading?
So I'm looking at, I'm sorry, is there an exhibit number here? Well, first of all, this is from, I'm looking at a chart from the 2019 rate case. It was the summary chart of from the stipulation on how the rates changed.
You're talking about case 19-00170.
I don't see the case number on here.
It's the matter of Southwest Public
Design increased by class 12 months ended March 31, 2019 is the heading on the piece of paper that I have here.
Okay.
Excuse me, Mr. Chairman, I was trying to show Mr. Luth to see if we're on the same piece of paper. I have a document from there, and I'll just to see if the numbers match up. There's a left column, present total revenue, and there's a residential number 114,023 under that. Am I looking at the same document you are, or maybe not?
Total present base revenues, and for total residential, if we look at that first column, it has 81,677,525 for total residential.
Thank you, Your Honor. I need to go back to the drawing board.
So, Madam Hearing Examiner.
Commissioner Hall?
Yeah, Commissioner Fishman, is this in direct testimony or is it a response to a bench request?
Boy, it's terrible. I can't recall where I pulled it from. I don't know. I had Robert pull it, and I'm not sure.
Okay, well,
testimony or
that's all right.
Case. Anyway, I'm not going to get into much more detail than just to say it's a fairly even rate increase across all the classes from that 2019 rate case.
Is that a question? Mr. Chair, was that a question to the witness?
No, it's not a question. I'm just pointing that out.
Do you have the document, Mr. Du Bois?
Your Honor, Chairman Fishman, I had thought I did, but it doesn't seem that I'm lining up with the same document. I'm
Okay,
not
if
sure
you
whether we need.
hang on just a second, Mr. Chair.
And I can't recall. I probably should have had sent that on to you, H.E. Hurst.
And tell me again what it is, sir.
This is the New Mexico retail settlement rate design increase by class, 12 months ended March 31st, 2019. And I believe this is an exhibit right off the prior stipulated rates case settlement.
What is it called? One more time, Steve. I have those exhibits.
New Mexico retail settlement rate design increase by class.
Yes, 12 months ending when? September 30th?
Okay. In the corner of the document, it should say uncontested stipulation, Exhibit A, page 1 of 10.
That's not on my copy, so maybe I'm a little bit off, but if we have that stipulated and can put it on the screen, that would work too.
Well, and that's what I'm looking for, so that's why.
You said March, 12 months ending in March?
31st,
Yeah, I don't have that.
2019.
I have 12 months ending September 30th, 2020. I just got this off the e-dockets in this case.
Okay. Let me see if I can get this put up and see if this is it. Mr. Chair. Okay, let me go back, share screen. Is that it?
Find out in a second. That looks like it.
Doesn't say 12 months ending March 2019.
Yeah, well, this is an Excel file. I can't find the other attachment, Commissioner Hall, right now. But I can tell you that it's the same numbers that I have in case number 19-170, page 1 of 10, Exhibit A.
And if we can enlarge that one step, it'd probably help folks.
And Chairman Fishman, Hearing Examiner Hurst, Commissioner Hall, I have found the document that Hearing Examiner Hurst referenced as Exhibit A to the stipulation in 19-00170 that has numbers. What I have is a PDF with numbers that match what I believe match what Hearing Examiner Hurst has put on the screen, and has the label 12 months ended March 31st, 2019. And I'm showing that to Mr. Luth.
Okay, so we're on the same page.
Mom.
Go ahead. And what was your question?
Well, actually, I didn't have a question. I was just pointing out that the rate increases are pretty even across all the classes.
Might be good to ask that in the form of a question, sir.
Okay. Are the rate increases ranging between, somewhere around 1% and 5% in the 2019 rate case, the last prior rate case for SPS.
That is a true statement. There is an anomaly in this particular version from the 2019 case, and that there's an additional RPS increase for the primary general and the large general transmission class that is not in this year's case. I believe that increase, I didn't work on that particular those two numbers, but I think it had to do with the end of the RPS maximum billing in 2019 with the Energy Transition Act. And the result of those additional amounts to both primary general and large general transmission, particularly made it a positive net increase. If you looked at what we have in common with this year's case, which is a base rate increase of $7 million approximately for large general service transmission and a $9.2 million FBPCAC decrease, really. You'd have about a $2.2 million overall decrease for LGST, large general transmission, general service transmission.
Okay.
I just wanted to point that out because it is slightly different from last time, the presentation.
Okay. Thank you for that. Then I want to go to the original filing on this rate case from SPS, New Mexico retail settlement rate design increase by class. And that's 12 months ended March. Am I looking at the wrong one? Yes, I am. 12 months ended. Oh, summary of changes in revenue. Test year ended September 30th, 2020. That's attachment RML1.
I believe you're referring to direct testimony in this case, sir?
And this is direct testimony, right?
Okay, I believe I have it.
Okay, thank you.
Oh,
And I'd see if we can get it up on the screen as well.
Well, it helps to know in advance.
I'm sorry.
so. Let's see. Madam Chair, Madam Hearing Examiner, is that document contained in the direct testimony? Is that what?
That's what Commissioner or Mr. Chairman Fishman said. It is an attachment to Mr. Liu's direct testimony.
Attachment RML1.
So where are the rest of the documents? Why aren't they there?
Let's see. RML1, okay, I've got.
Okay.
So, Mr. Chair, this says summary of changes in revenue, test year ended September 30th. Is that a correct document?
Yes.
Okay.
Mr. Luth, that's the same document you've got?
And
Yes, Mr. Chairman.
which page?
PDF page 80.
Attachment 4, page 80.
I said PDF page 80. It's attachment RML1, page 1 of 1.
Okay.
So we getting closer?
Okay. Is that it?
Yes.
So was this an attachment to the uncontested stipulation? Is that what
No, this is the original.
I see.
Direct testimony.
Direct testimony
testimony.
document. Okay.
Correct.
Excellent.
Anybody know how to rotate it?
Yeah, I'm looking for
Yes.
that on your buttons. too.
Right click, and it should tell you.
Thank
Right
you.
click on the document.
Yeah.
There you go.
Commissioner Hall, you're just a techie.
Star. Yeah, that's what I am.
So I'm looking at the percent, the column that says percent proposed increase in total revenue with Sagamore fuel reduction. And again, this is by class. And again, I'm seeing a fairly narrow range that the revenue increase across all the classes ranges. Well, I'll ask the question, Mr. Luth. Do the increases range between, with one outlier, range between 9.4% and 13%?
Which column are you,
Yes.
Mr. Chair?
Yeah, so I'm looking at the column that says proposed increase in total revenue with Sagamore fuel reduction.
Well, I don't think that's correct. I mean, it's got a 1.38 and it's got a 5.95.
Oh, I'm sorry, I missed the 5.95.
So I
So
think you
let's
should
say-
look at it again, Mr. Luth.
So I'm saying with basically one outlier here,
Two.
there are two outliers really. The area lighting service and the secondary general service.
Yes, with those two exceptions, I would agree with your statement of the range of the increases. I'll just repeat it for clarity in my own mind, if nothing else. 9.44% to 13.14% for the street lighting.
I'm sorry, can you do the percentages again?
Yes, 9.44% to 13.14%.
Thank you.
And I'm looking at LGST, which I'm assuming is the transmission customers, the large ones.
That's correct.
And what is?
Which column is that?
The row is LGST.
Oh, sorry. Yes. Okay.
It's the same column. And I'm seeing that was a proposed increase of 12.65%. Is that correct?
Yes, it is.
And again, for the residential, it's 9.44%, correct?
Yes.
Okay, so again, relatively close range there in terms of the percent increase. And now I'm going to turn to the stipulated Exhibit A, page 1 of 7. I'm going to go to the by class rate increases.
Glass as well. I can't see that screen.
Where do I find that document, Steve? Is that attached to the direct testimony?
So this is the stipulation,
Attached to the stipulation.
Exhibit A of the stipulation, page 1 of 7.
Okay. I have that.
And Mr. Luth, do you have that?
Mr. Chairman, I'm about to put it in front of Mr. Luth.
Okay, thank you.
Okay, can you see it?
Yes, thank you.
And what I want to point out here is that from the original filing, well, let me go to the numbers first. I'm looking at the far right-hand column, percent increase on total revenues, and this is including the fuel savings. And here I'm seeing for residential total, a 10.84% increase, and for large general service transmission, a decrease in rates of 1.48%. Is that correct, Mr. Luth?
Yes, it is.
Okay. So I'll just start with a big picture question. Why did it change so much how much of the revenue increase was borne by each class? Why did that change so much from the way we did 2019 and the way we did the original proposal in this rate case?
I can't speak to the, the discussion among the parties to the case. I was not, closely involved with the development of the customer class base rate increases, which is at issue in this case. The FPPCAC decreases are, measured upon the historical test period fuel rates that were in effect as a result of adding Sagamore to our generation fleet. And so customers were already experiencing those, reductions from Sagamore because it went into operation at the end of 2020. So the result that you see here in the base rate increases, once again, that are at issue in this filing are the result of discussions among the parties, all of whom are sophisticated, have technical advisors, and there's no precedent there. It's the result of the resolution of all issues in the case. Other parties didn't necessarily agree with my proposed revenue distribution. And so as a result of that, the parties worked together to come up with this settlement. And that's what they ended up with, which included, I believe, representatives of the residential and small commercial customer classes.
So now I'm going to go to page 50 of your direct testimony. As you're looking, I'll just quick read. So on line 4, the question is, why was the increase for residential and residential heating service limited to approximately 94% of the New Mexico average total bill percentage increase. The answer was the impact on the residential service and residential heating service was limited to reflect that SPS's large New Mexico capital investment growth in transmission and distribution over the last few years has been driven by the need to serve growth in commercial and industrial loads in southeast New Mexico, and not by residential and irrigation growth. The goals of reducing intra-class subsidies while minimizing impacts to customers can be inherently contradictory. The proposed rates mitigate the impact on residential as well as other customer classes to protect them from bearing an inordinate share of the investment and costs incurred primarily to serve current and future load growth in other customer classes. Non-C&I customer classes do not benefit as much as other classes from the increased transmission and distribution capital investment and associated costs that have occurred in recent years. Is that still your feeling?
Well, I support the settlement that we have as reflected in the stipulation. The parties were represented by, sophisticated technical advisors in the case. The company did give up some of the, revenue increase that it was requesting. And so as a result of all that, there was a settlement that was reached among all the parties.
Mm-hmm.
That has, that is shown in the Exhibit A to the stipulation.
Okay.
Obviously, not all customer classes agreed with what I had to say here. And so the result is the settlement.
Okay.
But ultimately, Mr. Luth, I think the question is, does this testimony that you used to support your original rate design, do you believe that it supports the rate design as set forth in the stipulation?
The rates were designed with many similar concepts in mind, targeted toward a $62.4 million change as opposed to $87 million change in direct testimony. Were we to go to a fully litigated procedure here, this would remain my testimony. However, a stipulation was reached among parties that once again are sophisticated with technical advisors, and all parties are supporting the stipulation.
Didn't answer the question, Mr. Luth. Do you believe that this section of your testimony that Chairman Fishman has read into the record that you used to support your original rate design, do you believe that this testimony supports the stipulation rate design?
Yes.
Okay, thank you. Go ahead, Mr. Chairman.
Okay, thank you. Thank you, H.E. Hurst. I'm going to step back and ask kind of a couple bigger philosophical questions. In reading through record on this case, I saw that with Sagamore and Hale in service, that we're now looking at 45% approximately of the energy delivered by SPS is going to be renewable energy. Is that consistent with your understanding?
Well, obviously with the two recent, increases in our generation fleet from those, Hale and Sagamore, renewable energy will be increased. In terms of 45%, that's not something I'm familiar with. So I can't comment on it positively or negatively.
Okay.
Excuse me, where did that statement come from again, Mr. Fishman, Commissioner Fishman?
I had it in my notes, but I cannot recall exactly where I saw that in the record. And yeah, I still don't have it. But anyway, that's the number in my head as I'm asking these questions going forward. And it may be off 5% or whatever, but as just kind of a order of magnitude statement. That's what I've got in my head. And I'm not sure again which testimony I saw that in. In terms of rate making, what challenges does that present to you, Mr. Luth?
I believe I do discuss some in my testimony with renewable resources being intermittent. Availability, they're not available all the time to the same extent, say, as a combustion related resource would be with very short notice. And I believe that has been reflected through the record in this case, and at least in pre-file testimony, where SBS generally has an energy-based allocation factor for Hale and Sagamore. Maybe the industrials have more of a demand-based allocation factor. Demand-based allocation factors, of course, would charge less of the cost of those facilities to an industrial customer than, say, a residential or small commercial customer with a lower load factor.
Mm-hmm. Does it make allocation of costs more challenging for you?
I think it does in the sense that it's more contested, but at least at this stage of the development and use of those resources, it's a different type of resource than what we've been familiar over the past decades, several decades. So I suppose the answer to your question is not more challenging, but yes, more interesting.
Does it change some of the basic assumptions that you use for allocation from what you've used in the past?
Well, I think I've been consistent in allocation of wind resources according to energy, and that's been consistent with prior PPAs where the charges for the energy purchased have been run for the fuel clause, which is an allocation based upon KWH, or at least line loss adjusted KWH or energy.
Mm-hmm.
But in the sense that it is a base rate item, Hale and Sagamore are new to is a new type of technology to the SPS owned fleet of generation.
Okay. In looking at the change from your original proposed increases by class to what came out of the stipulation, have you seen the elements that went into making that change?
Not quite sure what you mean by elements.
Well, the things the assumptions they changed to come up with that significantly different distribution of rate increases.
have I seen the assumptions that the parties may or may not have had in concluding in the distribution of the base rate increase?
Yeah.
No, I have not.
Okay.
No, I have not. I just saw the end result.
Would it be possible to make that kind of base rate increase without changing the way that wind costs are allocated?
The stipulation has no assumptions about any specific cost allocations. You know, there's no precedent established, going forward in another case or another 2 or 3 cases down the road.
Okay. How strongly do you believe in cost of service based rate making?
I think that is the ultimate goal of developing cost of service based rates. And in fact, my rate moderation proposals in direct and rebuttal testimony were not cost of service based.
Right.
Residential customers, for example, had approximately, I'd like to get a little bit more precise, but it'll take me a second to look it up. In direct testimony in my attachment, RML 4, the equalized return at proposed ROR would have had a $20.8 million increase for residential instead of the stipulation amount of $10.9 million. The proposal we had moderated the increase to residential customers as well as other customer classes.
Right.
Based upon the cost of service study.
Right. So in making your original recommendation, we look at New Mexico customers, and the common numbers you hear are about 20% live in poverty, 40% in near poverty, or under 200% of poverty. Was that a consideration, the number of low-income people in New Mexico and their ability to pay bills? Was that a consideration in your original proposal?
I can't really say that it was a consideration. I think that is the result. But nonetheless, we were talking about an increase here. And for people in those circumstances, almost any kind of increases might be something of a burden to them. Electric service is certainly a necessity these days to living, some kind of modern life. However, the company has costs that need to be recovered from residential as well as commercial and industrial customers.
In New Mexico, at least in rate making, unlike many other states, we don't have any special low income rates. So I know they do in California and a number of many other jurisdictions, certainly not all. When it comes to this issue of affordability of power to low income folks, does that influence your thinking in the way that you approach rate design?
To the extent that it has been mentioned or stated as a concern of the commission, it does, which is why we had rate moderation proposed in our testimony, specifically my testimony.
Okay.
But to assign all of an increase to, just a few customer classes that maybe based upon cost of service concepts should not absorb the full cost of the increase, it doesn't affect my, approach to cost allocation and rate design.
Okay. I'm concerned that because the stipulation on how the rates were designed, at least for me at this point, is black box. I don't know any of the details, even less than you might, certainly way less than you might have a sense of what's going on there. And I'm concerned that now we're moving into this new age, if you will, of large amounts of renewable energy on board, that we're not taking this opportunity. This is the first time that we're seeing this large penetration of renewables to re-examine how we're setting rates. Is that a legitimate concern on my part? Just your judgment.
I do think it's a legitimate concern, sir. It's a concern of mine as well. I would point out that, that lower income folks are probably often more affected as well by, pollution in our environment. So to the extent that we can clean up, emissions from our power plants in a cost manageable way, I think is a desirable goal for all concerned.
Okay. Would it be, in your opinion, and you're not a decision maker here, I understand, is that if we agree to some, if we agree to some rate design across classes as part of a stipulation here that didn't get us through a kind of a thorough study, that it would make sense to ask the parties to get together and do that hard work, because it is hard work to get everybody on board, that it takes to re-examine how we do rate design and in the new renewables / storage world?
I think that's the purpose of base rate filings, that, the company has its proposal, in this case it would be SPS, and then the various customer groups that have an interest in, say, SPS or P&M or EPE rates, put forth their positions to the extent they're inconsistent with what SPS or any of the other investor-owned utilities put forward. And through the course of a rate case process, whether it's through a commission order or a stipulation, some, if not all of those concerns are addressed. Rarely would it be perfect. We have, responses to bench request 5 specifically that I'm familiar with, that, there's a preference for working things out on a settlement basis to avoid acrimony that a litigated process might cause. And I think that's what we have in this docket, or pardon me, this case. And so to a certain extent, I think those concerns are addressed. Obviously, there's an increase for residential customers. And so that may remain a concern of some folks in the state. And it sounds like that may be yourself.
Yeah.
Commissioner Fishman, if I might, is your question more general to Mr. Luth about whether or not there might be a process, some type of collaborative process in the future where parties could get together and not just parties in this case, but affected individuals and companies could get together and do that kind of hard work that you're referring to?
I'm raising that as one possibility. That I would look at if we were to stick with a stipulation. But there's another part of me that is considering, and and I'll ask Mr. Luth, and this is just an opinion, so, would I be bat blank crazy for thinking that maybe it's a good idea not to say yes to a stipulation, just not to change revenue requirements or anything else, but just to be sure that we lay a solid foundation for future rate making as our other utilities become large penetration renewable providers.
I'm not sure. Is there a question then? Are you asking if I think that the stipulation should be scrapped? Because if that is the question, the answer would be no.
Not yet. I know you need to support the stipulation, and I understand that. So I'm just asking, is it crazy of me perhaps on the other side of this issue? Don't know for sure yet. But if to say, gee, maybe we're rushing into a rate design that's a black box that has all kinds of problems that we really haven't thought through yet in this case, and that we should think through.
Well, yes, we can bring people together. I think the stipulation did do that, and to the extent we need to bring in folks from other areas of the state or elsewhere, I don't believe this case has that involvement. However, all those things take effort and money, as you mentioned before, and the hard work.
Yeah.
And so, to the extent some customer groups may be underrepresented because of lack of funds, those are concerns of mine as well as trying to ensure that the stipulation is approved and authorized.
Mm-hmm. I'm going to raise a couple of, again, these are just kind of philosophical big picture issues, but it's all related to this idea of, gee, maybe it's time to step back and take stock of our rate making priorities and protocols for this new renewables age. If I was to go strictly cost of service, so I'm just positing a situation here, a scenario. This is not reality. And I had a lot of wind generation that was giving me cheap energy in the nighttime. In a pure cost of service situation, if industrial customers were using 80% of that power, say, in pure cost of service thinking, would one way to approach it, and I'm not recommending this at all, be to assign 80% of their generation during those hours, by those hours, to those customers, that low cost generation. Pure cost of service, just theoretical.
Well, that'd be probably outside the scope of this case because that would be a fuel matter. That is a position that the industrial groups have put forward. Our position has been that we don't have adequate metering at this time to accommodate that.
Mm-hmm.
However, we do have a recently filed advanced metering initiative pending before the commission that, given time to implement, would allow the type of metering and data to start developing time of use based fuel rates as well as general service rates.
Right. Now that scenario, I think, would work out well for the industrial folks because a lot of that wind power is pretty low cost. Is that a correct way to look at that?
Given your assumptions, yes.
Okay. So now I'm going to switch to another scenario. Let's say that XL, or not XL, but SPS, excuse me. Let's say that SPS had decided instead of investing in wind, to invest in solar. That would have created a lot of daytime energy, even going into our traditional old style, kind of obsolete coincident peak. Let's say they'd made that investment, made that decision as a utility. And let's say in this case, the residential customers are saying, well, boy, our percentage usage, this is daytime, our percentage usage of that resource is heavy. So we deserve a heavy allocation because of our time of use of those cheap solar assets. And the industrial folks deserve a lot less. Under pure cost of service theory, would that be a potential approach?
Well, I think you're talking about fuel once again, because solar has little to no fuel costs similar to wind. It's just a matter of wind occurs a little heavier at night than say solar would, because solar is not going to generate much at night, if anything. And when you're talking also about cheap solar, I don't know that at this time particularly, if that would be the case, to construct utility-owned solar units on a utility scale. That would mean another increase in base rates. However, would be another renewable power source.
Mm-hmm. So I'm just saying, if they had done solar instead of wind, and you were strict cost of service, you would be applying those reduced costs to residential customers. So that's what I'm getting at. Is that a correct way of thinking about it?
On the fuel end, you are correct. However, since we do not have solar resources at this point, there would be a rate-based item, and they would be, appropriately allocated
Right.
to share of this cost as well.
Right. So the point I'm getting at here, and I'll ask the question, is different customer classes in our new renewables world are impacted quite differently. If I look at pure cost of service, theoretical pure cost of service, they're impacted quite differently. And the utility's decision about which resource they build or they decide to acquire could have very different impacts depending on our rate, making assumptions on different rate classes. Am I making sense?
As a general observation, yes, you are making sense, and I agree with it. Yes.
Okay.
Different customer classes can be affected differently by different types of generation resources and availabilities.
You're plugging very well into this. Thank you. I didn't expect this to go this smoothly. So this raises a question for me. And again, I'm talking big picture theory and how this relates to our thoughts about rate making in the future is what might prove lowest cost for the system and is a good investment, depending which it is going to have very different impacts on rate classes. And I wonder whether that strict cost accounting, given that the utilities decision of resource can have such a big impact on one class or another, whether it's fair to even look at allocation of generation costs in that traditional cost of service light, in the formulas we use. So this is all philosophical, but
Yes, I think there's nothing wrong with taking a fresh look at things, from case to case, year to year, maybe even decade to decade. And that's what we've attempted to do, both in our filing in this case and as well as with the stipulation.
Okay. Okay. I appreciate your engaging with me in that short philosophical discussion. But to me, it really opens up a lot of questions, and thank you for acknowledging that those are legitimate issues to address. Now it's just kind of in my court about how we proceed with the stipulation, looking at those concerns. Is there any advice you would give the commission looking forward, and just again, apart from this particular case, as we look forward at these rate issues, things that we should be thinking about or considering apart from what I've already raised?
That's not something I'm really prepared to answer right now, sir. I think that as new technologies develop, new questions will arise. And those are all things that would be the subject of a future, rate filing or another type of proceeding.
Okay. Well, thank you. That's all I had. And I appreciate, I'm a little biased, but I appreciated your rate design a little more than what we ended up in the STIP. And I'm trying to figure out how to, well, I should ask one more question. We talk a lot about rate shock as well. And I guess 2 years ago, the net residential rate increase was 3 or 4%. And then this time around, it's close to 11%. Everybody has a different opinion of what rate shock is. But if I'm looking at compounded 15% in the course of 2 years, in your opinion, does that constitute rate shock for the residential class?
I think when you look at fuel cost reductions, well,
those are already built in. So that's all built in already.
You are correct. It would be our preference to keep rates stable, but on the other hand, the company must recover its costs of providing service in order to, generate adequate financing to maintain, reliable service.
Mm-hmm.
And I think it would be more shocking if, and this is not a risk at this time, but, if the company is unable to recover its costs.
Oh, yeah.
That the cost could accelerate or, service. It's not going to be impacted anywhere near soon, but if the utility has continual burdens placed upon it without adequate cost recovery, the road gets rougher. So
rest assured, I would never move the direction of the utility not getting adequate cost recovery. That's not our job on the commission.
I don't think it is either. I just want to make sure that it's understood that we're in it together. We're trying to provide, good service for our customers, for economic growth, for our region, as well as, better lifestyle for our residential customers as well.
Actually, I'll ask one more question. I wasn't in on these discussions, but it's, again, in the testimony, I can't tell you exactly where, but, that it's mostly, as I think everyone knows, industrial is driven by the oil and gas industry to a large degree in the territory. Was there any talk that if instead of getting 1.5% decrease, they got a 3% increase, that would somehow drive those operators out of New Mexico and hurt the economy?
I'm sorry, I wasn't privy to those type of conversations.
Okay.
I don't feel prepared or, to comment on it.
Okay, that's fair. Okay, I'm going to leave you alone now. Thank you very much. I appreciate the back and forth.
I enjoyed it too, sir. Thank you.
Commissioner Hall, do you have any questions for Mr. Luth?
I do not.
Very well,
Thank
thank
you.
you. Mr. Luth, I have some questions for you, but seeing that it's 5 o'clock, I'm going to wait until tomorrow morning at 9 and ask my few questions for you, just so that we have an idea of how things are going to proceed tomorrow. It's my understanding that the commissioners will not be available until approximately 2 o'clock. Is that right, Mr. Chair, Commissioner Hall?
As a rough guess, yeah, our open meeting, I figure it'll go to about 2.
Okay.
30 or 2.
Will you be prepared then at that time to continue? I did email you. It appears that SPS has provided its answer to your bench request, Commissioner Hall. But you still have the other 2 witnesses that I believe you required to file, and they still have until 5 o'clock tomorrow. But apparently Mr. D'Ascendis did answer that. So I don't know if you will have an opportunity to look at that and then ask questions of him tomorrow afternoon. I know he is listed as one of the witnesses that you want to ask questions of, Commissioner Hall.
Correct.
And
Yeah, I think I think in the interest of moving this proceeding along, I could question Mr. D'Ascendis tomorrow.
okay. And I believe Commissioner Hall, Mr. Chairman, that completes your questions for the SPS witnesses.
Yes.
Okay. I need to ask SPS about, we still have 4 outstanding bench requests. We have number 5, which is the updating of the S&P off-book liability for PPAs. Mr. Dubois, status?
Your Honor, I sure hope we have that one done this evening, but we don't have it ready yet.
Okay. How about bench request 6, the outstanding PPA liability?
Your Honor, I think my numbering may be off then. I had sorry, one moment, please. I had 5 as the PPA liability. I had 6 as what we were treating for numbering purposes as Commissioner Hall's set that was sent on Friday. And to be clear and transparent on that, I believe Mr. D'Ascendis provided the response to number 1 in that, which was what he was specifically directed to respond to. And
let me
rest of the
clarify, Mr. Dubois, let me clarify. I'm talking about hearing bench requests. Okay, obviously I initially indicated to Commissioner Hall that Mr. D'Ascendis had responded to her bench request. I'm talking about the hearing bench requests that have been issued during the hearing. And so bench request 5 was an updated S&P off the book liability for PPAs. Bench request 6 was an outstanding PPA liability number. Bench request 7 was Commissioner Hall's request today for information on SPS's cash flow position. And bench request 8 came about during Ms. Martin's testimony, and it was an update or S&P document about that she referred to on how it makes credit adjustments. And that was, I believe, something different than bench request 4 from Mr. Shipman. And so those are the 4 outstanding hearing bench requests that I have.
So, Your Honor, I think 7 and 8, I think, are straightforward, and we'll be getting out responses to those very shortly if they haven't already gone out the door. Okay. On the 5 and 6, my understanding had been that the testimony was that as to S&P's information, internal S&P information on how exactly they are calculating on the PPAs is not something that SPS is privy to. However, we were going to be providing our PPA data, and that I had that identified as number 5.
Commissioner Fishman, it was your bench request.
Mr. Dubois, I have to apologize. I drifted off in thought at the end of the day. Could you repeat what you just said? I apologize.
Chairman Fishman, yes, we're trying to figure out where we are with hearing bench requests 5 and 6.
5 and 6 were which information?
I thought that bench request 5, you wanted updated S&P off liability, off the book liability for PPAs.
Okay.
And so let's take them one at a time. Mr. Dubois says what they have is SPS information.
Mm-hmm.
Is that correct, sir?
Yes, Your Honor. I believe the testimony was, I can't pull up the transcript quickly enough, but I believe it was that SPS is not privy to the internal S&P information on their precise treatment, but what we said we could provide, Your Honor, Mr. Chairman, is our data on PPAs and our understanding of its treatment.
So I would be able to compare essentially your total commitments to what they put down as the liability in their credit evaluation. Is that the information I would then have?
I want to say yes to my understanding, but that may be beyond my lawyer capacity to answer the finance.
That's
piece.
my goal, just so you know. So I think if you provide all your information and you can provide the latest updated SPS credit report that lists, because I have the 2019, I don't have 2020. That might be enough to get me there. We don't need to get more detailed than that.
So
Understood, Mr. Du Bois?
I think so, Your Honor, Mr. Chairman. And what I propose to do is provide our best attempt to give Mr. Chairman what you're looking for all in one bench response rather than trying to split things between two of them.
Okay,
I
and
approve. Thank you.
bench request 6 was the amount of your outstanding PPA liability currently.
And Your Honor, I think what I just proposed, and the chairman can indicate whether he heard this or agreed with it correctly, but what we're proposing is to combine our best effort at answering both the S&P information and the company information in
Okay.
one response rather than trying to split it into two.
Mr. Chairman, does that suffice?
Absolutely.
Very well.
Makes sense.
Thank you,
Madam Hearing
Mr.
Examiner.
Yes, Commissioner Hall.
I thought my bench request was also numbered 6. And it was simply a request that Mr. Diascendis extend the table that he had prepared for 1 year for out 20 years, or retrospectively 20 years on volatility.
Commissioner Hall, there's just a little confusion. Your bench request, your written bench request, what is number 6?
Okay.
Okay.
Mhm.
And it's to more than one witness, right? It's to 3 different witnesses.
Correct.
Okay. I am specifically referring to the bench request, oral bench requests
Oh, that
that
generate
have
in the
been
meeting.
issued
Hearing.
during the hearing.
I understand now.
And your bench request about cash flow that was issued today is bench request 7.
Correct.
Okay.
Okay, fine. Thank you.
Okay. Okay, that's what I have with regard to that.
Your Honor, if I may, one point I wanted to make sure I'm communicating is I believe Mr. Diascendis provided his answer to Commissioner Hall's Friday bench request 6, number 1, which is what he was specifically directed to respond to. But to be clear, I believe he may still be intending to respond to additional items in that set per the instruction that your parties could elect to respond to ones additional to the ones they were specifically required to respond to. And that has not happened at this point, as far as I know. So I just wanted to be clear about that.
Okay, so then basically it might not be the best to schedule him for 2 o'clock tomorrow if he still intends on responding to more of the bench request.
And I can update Your Honor first thing in the morning on where that stands.
Okay, yeah, the only problem is that I may not be able to contact the commissioners. So commissioners, just, try to let me know if it looks like you're not gonna be back. And so we'll know what to do at the hearing. What I'm proposing to do is at 9 tomorrow, I will finish my questions with Mr. Luth. You'll have an opportunity, Mr. Du Bois, to do any follow-up on the chairman's questions and my questions. And then what I would propose to do is to have Mr. Berger, who I have questions for, and to have Mr. Lytle, who I have questions for, and then have us deal with the commission exhibits. And depending on where that takes us, I will be reviewing to see if I have questions of any other SPS witnesses other than the 3 that I just identified. And then, of course, Mr. D'Ascendis coming back. Because if that's, if we don't have any other questions other than those 4 witnesses, and the commission doesn't have, if Commissioner Chair Fishman doesn't have any questions of the witnesses who responded to his bench request, then like I said, then we're going to go through those 24 and see, since he has indicated he wants them in the record, then we'll see if there's any objection. And like I say, see if there's any other SPS witnesses. And if we don't, then most probably after lunch, I'll go ahead and begin the next party that we have. And I don't show, at least at this point, that the commissioners have questions for Mr. Pollack. I have a few.
Not Commissioner, but H.E. Hurst, I'm sorry.
Mr. Chair.
I wanted to give you a heads up that on Thursday at about 4:15, I'm going to be pulled aside, unavoidable. And if you can schedule to be sure that I don't, one of the witnesses I need to question is not up at that time, that would be helpful.
Yes, sir. I will do my best to do that. I know that you do have questions for the majority of the rest of the parties, but not all of them. Again, I will review my my witness list and make an effort tomorrow, after we've gone through the SPS witnesses, to let the other parties know where we are. And as I told you last week at the pre-hearing, I can go ahead and excuse your witnesses, but if something comes up with one of these other witnesses that the commission believes that it needs to question your witness, then you're going to have to make your witness available for the commission's questions in order for us to have a full, complete, and accurate record. So with that being said, is there anything that anyone else needs?
Madam Chair, Madam Hearing Examiner.
Commissioner Hall.
So, if you need to contact me, you can certainly text me.
Okay.
But I can't speak for Steve, but I think he reads his text too. But I think you could probably reach any commissioner that way. But
I appreciate.
I can be ready to question Mr. D'Ascendis, but if he's needs to take the full day to prepare, if that's what Mr. Dubois was saying, I can understand that.
Commissioner Hall, he might be responding to more than just the first part of your bench request. So it probably makes sense to, for you to question him on all of his response to the bench request. I thought I didn't realize he only responded to part of the bench request.
Oh, I see.
So that's where he is. However,
I see. Okay. Now I understand.
I believe that you have some questions perhaps for Mr. Cooley, who I have questions for.
I don't anymore.
Okay.
Mr. Grant satisfied my need for that information. So
okay,
I only have questions for witness Garrett and Kale.
And Mr. D'Ascendis.
And briefly, Mr. D'Ascendis.
Very well, Commissioner. Well, then that puts Mr. Cooley in the lineup for in the morning after Mr. Luth. Then I have So I have 4 SPS witnesses that I know I need to talk to in the morning. Not many questions for all of them. Okay, anything further that we need to discuss? Well, hearing nothing, I thank you all. Mr. Luth, I'll see you in the morning, and everyone else. Appreciate people's time, and we are recessed until 9 o'clock tomorrow morning. And Mr. Lee, I'm going to call you.
Thank
Yes,
you,
ma'am.
H.E. Hurst. We'll
Thank-
catch you tomorrow, hopefully.
Thank you, Mr. Chair, Commissioner Hall, parties,
Thank you.
witnesses. And I'll see if I can actually end the meeting. Okay, there we go. Good evening.
Bye.
Evening.